calendar. Let me see who's here to begin with. Position number one, Tony Cantizone. That has been further noticed to a status calendar on January 3rd next year. Is anybody here on the Cantizone case?
Yes, Judge. Good morning, Judge. Ms. Catazone is here in court, and we do understand the reset to January 3rd, and I'll speak to Ms. Catazone.
Okay, that's what you requested yesterday. Is that not correct, Ms.
That's
Ellen?
correct, Judge. That is going to be a mental health request evaluation, and that's currently where that case is.
Okay, very good. Thank you. Position number two, Rashad Flowers. The motion in this case was withdrawn. Is anyone here on that case? Position number three, Bobby Jones.
Yes, Judge, that's my case. Ms. Jones, yes, no? Or one of you, Ms. Jones, or were you waiting for something else? Judge, I believe that she is on the way. She plans to be here for a plea if I could have an opportunity to call her.
Okay, very good. Position four, Elena Stander.
Morning, Judge.
Morning, Mr. Sullivan.
Ms. Standard, President, we have motions that need to be heard.
Okay, I have those motions and I have reviewed them. The state ready?
Yes, Judge, we have two officers here, Officer Lambert and then Officer Thaxton's parking. So when he gets here, we'll be ready to go forward.
Okay, very
Your
good.
Honor, I thought I could clear it up. We don't need Officer Lambert. So he can be excused, but this is state's way this. I spoke to him before.
Okay, well, whomever,
Let me just, let me confer really quick with defense counsel. One
okay,
second.
let me finish the calendar real quick, Ms. Reiser. Position number five, Ariana White.
Good morning, Judge. Ms. White is present here in court. We are prepared to go forward with a single immunity motion whenever the court's ready.
Okay,
And Your Honor, the state is prepared to go forward. Mr. Williams, the victim, is also present in the courtroom. We also have an officer who's on call. We would ask that if there is a priority to the motions, Mr. Williams flew in from Texas. I believe his flight leaves at 6 p.m. today. So we could be put first so we could get his out of the way and he could possibly go home today versus having to reschedule a flight.
okay, well, so far I see that we only have two motions, so I'm hoping that we'll get him there well before 6.
Yes, Your Honor.
Okay. Do we have, that concludes the regular calendar. I also have Ernest Abernathy.
That's correct, Your Honor. Attorney Kuhn here on behalf of Mr. Abernathy.
Okay, is Mr. Abernathy with us?
Yes,
All right, and whose case is this for the state?
Your Honor, that is my case, and that'll be a plea this morning.
Okay, can we go ahead and take that plea?
Yeah, Judge.
Okay, is there anyone else on the Zoom call that I'll need to address this morning aside from Mr. Abernathy?
not for us, Judge.
Okay, very good. So let me know when you're ready, Ms. Waldrop.
Yes, Judge.
And good morning, Mr. Abernathy. If you can raise your right hand for me, sir. And unmute yourself first. Can you unmute yourself for the court?
Mr. Abernathy, you'll see, just like when we've Zoomed before, you have a button to unmute yourself. You're going to have to click that button. I apologize, Judge. We did practice this.
That's fine. It happens all the time.
I think it's harder with people on their cell phones versus computer. Do you see the button, Mr. Abernathy?
Usually those are.
There you go. So you should find the button.
Is it,
Yes, now you were unmuted, so please go back to the video now. There you go. Sorry about that, Judge. Thank you for your patience.
No problem. Good morning, Mr. Abernathy. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
absolutely, yes, Your Honor.
Okay, very good. You can place your hand down. Ms. Waldrop.
Yes, Judge. Mr. Abernathy is pleading to one count of battery family violence. Count two, the criminal trespass. I did tender a null clause to the court on that count. And pursuant to a negotiated plea, the recommended sentence is 12 months probation for the defendant to complete a 24-week family violence intervention program. That is the VVIP program, and alcohol and drug evaluation and any treatment deemed necessary, and to have no further violent contact with Ms. Mary Abernathy or Mr. William Stone. We did agree that probation could go non-reporting upon successful completion of all conditions. Counsel, do you stipulate to a factual basis, venue, and identification for purposes of the plea?
Yes.
Nothing further from the state judge.
Yes, counsel.
I do want to let the court know, and we're going to go ahead and email it over. We did complete his drug and alcohol evaluation. We got that yesterday from Dr. Grace Price, and there are no recommendations for him. Mr. Abernathy, do you understand the plea?
Yes,
Do you understand and agree to all of the contents of the plea?
yes, I do.
And Your Honor, I have not taken a plea in your courtroom. Do you need me to walk through the read, write, English? What grade did he attend and those things?
No, that's fine. You've already done that with him prior, and he has gone over and signed the plea sheet. It's my understanding.
That's correct, Judge.
Okay, no, that won't be necessary this morning.
Okay, thank you.
Anything further?
Nothing further. May we be excused?
No, let me go through it with him though, and take the plea. Mr. Abernathy, it's my understanding that in case 20 CR 004360B, you wish to plead guilty to battery family violence. Is that correct?
That's correct.
Are you under the influence of any drugs or alcohol this morning?
No,
You've been represented by counsel. Are you satisfied with her representation? Was that a yes?
yes,
You
Yes, sir.
understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
yes, I do.
Has anyone forced or coerced you to plead guilty?
No,
I'll accept the plea as negotiated. Mr. Abernathy, when you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get this done, I've seen that you've done some of it already, the sooner you won't have to be on reporting probation and you won't have to pay those probation fees. Have we already given you, or already given him where he needs to report to probation, counsel?
No, Judge, I have not seen that.
Okay, we will get that to him and to you. And Mr. Abernathy, I ask that you report within the next 2 weeks, okay?
yes, Your Honor.
All right, very good. So we'll get you that information. I've signed the null pros. Anything further this morning, counsel?
No, Judge.
All right, you all have a good day. Thank you.
You too. We appreciate the court's patience. Thank you very much.
Not a problem. Okay. Okay, you can put them down now. Ms. Rosenhover, did your client appear?
She has not yet, Judge. I've texted her and called her if the court could.
Okay, no, that's, I just wanted to see if I could get a plea out of the way so she wouldn't have to wait through the motions, but since she's not here, I guess that won't be a problem for now, but just let me know.
Will do.
Do we have all the witnesses here? Well, Ms. Helen's not in the courtroom, so let's go ahead. Position number 4. Is everyone ready on the standard case?
Judge, state's ready. Officer Thaxton's, he'll be here. The defense does have a constitutional speedy. We can address that first. Obviously, won't have witnesses for that, but defense can, we can start with that.
Okay, that's fine.
Defense is inclined.
Yeah, that's
Okay. And then when Officer Thaxton gets here, then we can do the motion.
Okay. Are you gonna need him first for your motion?
No, Officer Lambert will testify first.
Okay, so good morning, Officer Lambert.
Judge, if you just give me a minute here to pull my file out.
Procedural posture. Piece on the record before we start.
Yeah.
Yes, I'm not for this one. Only received it. That was the order. Status calendar.
That's right.
And Judge, since this is a or a motion to dismiss based on the violation of the constitutional speedy, council and I have agreed to the timeline of events, and so we want to go ahead and put that procedural posture on the record for the court.
Okay, the court calls the case of Elena State versus Elena Standard, case 21 CR 0073667F. Yes, you can proceed, Ms. Reiser.
Yes, Judge. The defendant was arrested on June 6th, 2021 in the city of Alpharetta. On August 17th, 2021, the defendant had her first court appearance, plea and arraignment in the municipal court for the city of Alpharetta. On September 21st, 2021, the defendant, through her attorney, filed a demand for a speedy trial, and the case was bound over to the state court of Fulton County. On October 12th of 2021, the solicitor of Fulton County, our office, received the file from the city court. On December 7th, 2021, the Solicitor General filed formal accusations.
December 7th?
December 7th, yes, Your Honor. On April 19th of 2022, the defendant had a plea and arraignment calendar in front of Judge Richardson. On May 31st, 2023, the case got transferred to the Orca division. And that order was signed by Judge Richardson, filed into the docket. On July 13th, 2023, the defendant had a status conference in Orca. And on October 19th, here today, we are here for motions. So it's my understanding the total time from arrest to the motions date today is a little of 28 months since her arrest. So that's the time we'll be arguing about.
Okay, and that's agreed upon by you, Mr. Sullivan.
Judge, excuse me for not having enough coffee this morning. Part of the discovery that we received from the state that was, I believe, electronically filed contains our speedy trial demand. I do have my stamped copy from Alfred Municipal Court that I'd like to submit as defense.
We have the copy of that, and that was in the bind over packet. The state has no objection because it was demanded.
And Your Honor, I'd like to have Ms. Standard take the stand to go over the harm that she suffered by this
Okay.
delay.
Good morning, Ms. Standard.
Morning.
I think that we might need would you mind just standing at the podium here? Would that be all right with you all?
That is fine, Judge. I did explain to her the setup here is a little
Right.
formal courtroom.
Yep. It's Alana Stander.
And Ms. Standard, can you spell your name for the record?
Yes, it's ALANA. Last name is STANDER.
And Ms. Standard, are you the one that's charged in the accusation?
Yes, I am.
I'm gonna, you're the one that was arrested back on in June of 2021.
Correct.
And make sure that you speak up, record.
Yeah, can he use the microphone?
Let's make sure the mic is on.
I think it is. Can you hear me?
I can hear you. I can't hear you, attorney.
Okay. Is the microphone on?
It's on, Judge.
Okay.
Can you hear me
That's-
now?
Yes, I can hear you now. Thank you.
Okay. Now, Ms. Stanner, you hired our office fairly quickly after your arrest.
Yes,
Okay. And you were aware and a part of the decision to file a constitutional speedy trial demand in Alpharetta?
yes, I was.
Okay. Can you explain to the court, to the course of this 28-month delay, how this delay has affected you personally, career-wise, family-wise, health-wise?
Yes, I can. So shortly after the incident, I was promoted to a more senior level with a more rigorous travel schedule. And part of that involved me needing to go to Canada over the last year. And I haven't been able to do it due to the pending charges. I also travel very regularly, at least once a month for a week to go see customers. And it's caused a lot of stress and anxiety every time I have to plan these travel events, because if I cannot go because I have to come and do court or deal with anything related to the case, it means I drop my customers and I drop my company. And that then puts me at a competitive disadvantage in my company and in the market. Excuse me, Judge. Personally, it's caused a lot of tension and stress between my fiance and I, fighting over the proceedings, how to deal with it all, how to get through it. Often these fights will result in panic attacks. Those panic attacks happen quite often and involves me throwing up, feeling like I can't breathe, just a lot of anxiety and stress that I felt with the delay being so long, and not being able to get on with it or deal with it and put it behind me.
Has this affected your ability to advance in your company?
Yes, it has. Yes.
Can you explain to the court how that has affected?
Well, we have certain targets that we have to hit sales wise. And if I cannot go to Canada and go and further these partnerships and travel with my other customers and let them down, then I do not close those deals and I do not hit those targets, and thus I cannot move up.
How has it affected your relationship with your partner?
Yes, it has. With the fighting, the tension, it creates a lot of stress. And he then has to deal with me not being able to focus on anything else, because all I'm focused on is the anxiety I feel around the case.
That's all I have, Judge.
Judge, is it okay if I remain seated for the microphone?
That's fine.
Madam Court Reporter, can you hear me?
Yes, I can.
Okay, thank you.
Mhm.
All right, Ms. Stander, you would agree with me, when you were arrested, when you were arrested, you were in the hospital, correct, after the incident?
Yes, I was.
Okay, and you were released on citations, correct?
Yes,
And you never had to go to jail, or you were never incarcerated, correct?
correct.
Okay, and this entire time that you, from June 6th, 2021, you've remained out of custody.
Correct.
And you just testified that shortly after your arrest in this case, you were actually promoted in your employment. Is that true?
That is correct.
And since you've been from this incident on June 6, 2021, you've maintained employment the entire time, correct?
Yes, ma'am.
And you've been able to make a living?
Yes.
and provide for yourself and your family.
Yes,
And your employment didn't terminate you or suspend you for this incident, correct?
no, ma'am.
And in terms of your relationship with your partner, you are still together?
Yes,
Is he in the courtroom today
he is.
supporting you?
Yes.
And you're still engaged?
Well, we recently got engaged. Yes. At the time, he was just my boyfriend.
And during this time, I think you had just testified that this court case has prevented you from traveling because you have court appearances. Is that what you testified to?
It creates anxiety and stress whenever I have to plan my travel arrangements up until that point, not knowing whether I can do it or not. And I might have to tell my supervisors and tell my customers that I cannot make it.
Okay.
It's about the
but you-
stress. Sorry.
No, you're okay. But you are still allowed to travel if you need to
Yes.
for work,
Yes.
and you haven't been prevented from traveling, correct?
Other than Canada, not being able to go to Canada due to the pending charges. Yes.
Okay. But you're allowed to travel within I
The
guess.
US.
Who told you couldn't travel to Canada?
Just that it would make it more difficult to travel and to get in. So
Okay, so the testimony, it's not impossible to travel to Canada for work. It would just be hard to, correct?
yes.
Okay. No further questions, Judge?
Nothing, Judge. Okay. Thank you, ma'am.
Thank you, Judge.
Any other witnesses?
No, Judge, just argument.
Just argument on the state's behalf as well.
All right.
Your Honor is probably familiar with the Barker versus Wingo and Doggett factors as far as the constitutional speedy trial violation. Barker versus Wingo sets out the threshold determination for further analysis, and I believe Doggett actually applies that analysis to misdemeanors. And the case law indicates that the minimum threshold for further analysis, 1 year delay. With 48 months that pass, that most certainly be satisfied. That initial threshold for the court's further analysis. Then the 4-part factors come into effect after that, which include the length of delay, the reason for the delay, the assertion of the right to the speedy trial, and the prejudice to the defendant. More recent case law, I believe, coming from 2008 on, the courts, including our Georgia Supreme Court, indicates that the trial court, in determining whether there's a constitutional violation or not, are supposed to weigh each factor, looking at whether it weighs more in favor of the state or in favor of the defense, than take an overall analysis as to whether a violation has occurred. So looking at the delay, 28 minutes is uncommonly long for a misdemeanor case. I believe the National Council for State Court Judges indicate guidelines of an ideal guideline of 6 months from arrest to trial. Now, I understand the issues with Fulton counties make that a bit more challenging, but most certainly 28 months is uncommonly long for a general misdemeanor case, especially in a DUI case where when a case is transferred from a municipality, the prosecution essentially has everything in their file. Also, especially since what was contained in that file that the solicitor's office acknowledged was that demand for a speedy trial. So weighing that particular factor, that should weigh, just the length of the delay alone should weigh in favor of the defendant. Then the next factor that the court is to consider is the reason for the delay. What that generally boils down to is who caused the delay. Most certainly it was not Ms. Standard. She exercised her right to a constitutional speedy trial on September 21st of 2021, merely months after the arrest, her very second arraignment court date in Alpharetta. I would give the state that the time between the first arraignment and the second arraignment, that 1 month delay is probably neutral. And should be, so the factor should be actually 27 months instead of 28 months as far as who actually caused the delay. The courts, when looking at the state causing the delay, doesn't just include the state court prosecutor. It includes the municipal courts, judges, clerk's offices, appellate courts. That's all lumped in as under the state's reason for the delay. And most certainly in this case, a neutral 1 month delay out of 27 months, that weighs in favor of Ms. Standard. So you got two factors now weighing in favor of Ms. Standard. The third factor that the court is to consider is the defendant's assertion of the right to a speedy trial. Well, that was done right away. Way back when this case was in Alpharetta, the prosecution received that merely a month or two right after the case was found over. So most certainly that right was asserted and they are aware of it. And so that assertion of the right was made timely and it stays with the case through the pendency of the case in this court. So that weighs in favor of Ms. Standard. And then the fourth factor is the prejudice to the defendant. Now, I'll concede that there's plenty of case law out there that says general anxiety is not enough to trigger prejudice to the defendant in and of itself, general anxiety. But we go further here. She was suffering more than general anxiety. She was having anxiety attacks to the point that she was throwing up. She was having anxiety attacks and issues with this case to the point that it created tension and fights with her partner. The delay of this case affected potentially her advancement in her career, being that the potential prohibition from traveling to Canada as part of her business. And so those things weigh in favor of the defendant, although I'll agree slightly. And so when you take into consideration the totality of the circumstances, weighing all four factors, the balance tips in favor of the defendant, especially when that right was asserted 2 years ago. And the state was aware of that right was being asserted 2 years ago. Their file was complete 2 years ago, and the delay is unexplained. And so we'd ask that you grant our motion to dismiss for violation of her constitutional speedy trial rights, Judge.
Thank you. Supervisor?
Thank you, Judge. The state will concede in the fact that the case has reached the threshold, the 12-month threshold, to then apply the four factors. The delay that we're calculating here is approximately 28 months. So I know the case law is clear once we get past that 1 year. That's the presumptive prejudicial effect. So in the analysis of the four factors, the length of the delay. So we're looking at about 28 months from June 6, 2021 until today's motions date. Judge, the length of delay in and of itself is not a reason to grant the motion for discharge. There's no bright line rule that the length of delay must be weighed heavily against the state. There's a couple cases, Durham v. State, 355, Georgia Act 426, which is a 2020 case where a court found no violation of the constitutional speedy trial right where there was a 6-year delay. And again, in Holland v. State, 357, Georgia Act 87, another 2020 case, where the court did not weigh a 4-year delay heavily against the state. In terms
What's
of,
the site on the Holland case?
I'm sorry, which one?
357 Georgia Ave.
357 Georgia App 87, 2020 case. In terms of the reasons for the delay, Your Honor, the second factor, I would argue that those are not wholly attributable to the state. Obviously, deliberate, intentional attempts to delay a trial can be held against the state, but there's absolutely no evidence that was presented today, testimony, or really throughout the procedural posture of what we agreed to, stipulated to, that there's been an intentional delay or a bad faith on behalf of the state. Judge, you're well aware that the backlog in Fulton County is extreme, and we have a very overcrowded docket. This division, this Orca division, was created to help the backlog of the trial division. Hence why this case was originally with Judge Richardson and then transferred to this division to help clear up the dockets of the state court divisions. The case I'll rely on, Judge, is State Buckner, 292 Georgia 390. And that just says that unintentional delays such as caused by mere negligence or overcrowded dockets of this court should be weighed less heavily against the state. So it's my position, Judge. I know it's a 28-month arguably delay, but that delay is due to the overcrowdedness, the backlog created from COVID. This case was actually right after the June 6, 2021. So that's when the order tolling all the jury trials lifted. So we had that extreme backlog from the 2020 cases that we're still trying to get through today. In terms of the defendant's assertion of her right to speedy trial, obviously the state concedes that she did assert her right to a jury trial and constitutional speedy trial in municipal court. I will say her arrest date was June 6th. That right wasn't asserted until September. So that's about 3 months that I'm asking you not to weigh against the state because she didn't assert her right to a speedy trial until September. So if the court excludes that 3-month period, then we're really looking at about a 25-month delay. And then in terms of the final factor, Judge, prejudice to the defendant, within that factor, there are 3 sub-factors the court is to look at. The first one is preventing oppressive pretrial incarceration. Obviously, the testimony today was that Ms. Stander was never booked into the jail. She never went back into custody. She was released from the hospitals on citation. So there has been absolutely no pretrial incarceration. In terms of the second sub-factor, the court is to analyze is minimizing the anxiety and concern for the defendant. As defense counsel pointed out, obviously, their just generalized concern and anxiety is not enough to warrant a dismissal of the charges. Specifically in this hearing, Judge, there's not sufficient evidence to show that the defendant is suffering from any more anxiety and any more concern than any other defendant in any other criminal proceedings. The testimony today was that she remained employed while this case was pending. She was promoted in her employment while this case was pending. She's still working. She's able to work, take care of herself and her family. It's not impossible to travel. She testified on cross-examination that it's not an end-all be-all that she can't travel to Canada. What she testified to is that it would be hard to travel. This case is not holding her from traveling or maintaining employment or gaining any other promotion. It may be a little bit more difficult, but it's not impossible. And also she's still she testified that she had some issues within her, with her and her partner. Obviously he's here, he's supporting her, they're still together. So I don't think there's been sufficient evidence at all that there is any anxiety or concern that rises to the level of dismissing the case, Your Honor. And the final sub-factor the court needs to analyze is limiting the possibility that the defense is impaired. And so when the court is analyzing that sub-factor, you have to look to, has the defense, based on the delay, been impaired? The answer to that question, Your Honor, is no. The witnesses are still here. 2 of them are sitting in the jury box, Officer Lambert, Officer Thaxton. I've spoken with the other witnesses, the nurse who drew the blood, the GBI toxicologist. All the evidence has been turned over. All the witnesses are still here. This is not, that factor is just not a generalized claim of harm to the defendant. The court really has to analyze, has the defense been impaired due to the delay? And the answer is no, Your Honor. And so I think when you look at the totality of the circumstances and the length of delay is 25 months, 25 to 28 months, and the reasons for the delay, the prejudice to the defendant, all of that will lead the court to decide that to deny the defense's request for discharge and acquittal.
Thank you, Ms. Reiser.
Thank you.
Anything further, counsel?
Judge, just for case law for the court's consideration, State versus Johnson, that's 749 SE second 828. That's Georgia Court of Appeals case from 2013. Your Honor, that case essentially, as part of the holding, that excessive delay has a tendency to compromise the reliability of trials in ways that neither party can prove or, for that matter, identify. That's part of the analysis that the court can consider in granting a motion or denying a motion for a speedy trial violation. Also, Your Honor, Over versus the State, that's OVER, that's 690 Southeast Second, 507. That's a 2010 case. Your Honor, that's I should have cited that when I was making my early argument. That's the case that eventually says all state actors are involved in the delay from the municipal court forward, court staff, prosecutors, even the appellate court, to the delay as part of the state.
690 Southeast Second, 502 or 507?
507, Judge. That's a 2010 case.
I will take it under advisement and look at the cases that you all have presented this morning. Let me first say or ask both counsel. We had a status in the Orca division on July 13th of 2023. Was I the judge at that time?
You were not.
I was not. Was the court made aware at that time that there was a speedy trial demand? Do either of you know?
Judge, I don't
inform the court.
That hearing. We did file the motion to dismiss this week, but the speedy trial demand was sent over to the state, and we were made aware that they were aware of it through the discovery process. What happened on the July date was we just set it for motions and they assigned us this earliest date.
Okay, I guess I was wondering because from July till now in October has been a significant a number of months. And I wonder if anyone made the court aware at that time, at that status conference, when someone must have demanded a motions hearing, that there was a speedy trial demand.
I frankly don't remember, Judge.
I don't remember, Your Honor. Honestly, I think when that happened, there was just, we need to move it to motions. And I think that's what the generalized consensus was. I don't believe it was any specific talk about this is what the motions are going to be. It was just, we need to set this to motions. And then, yes, that's correct. The motion to dismiss was filed this week and counsel and I discussed it.
Okay, well, I guess my issue is that on April 19th of 2022, there was a plea and arraignment in front of Judge Richardson. At that time, on April 18th of 2022, counsel filed a number of motions in this case. The motion to dismiss because of the speedy was not included in those motions. As such, I would say that the court was not aware, Judge Richardson would not have been aware that there was going to be a motion for dismissal. This court was not aware. I was wondering, because I look over my cases well in advance. I pulled all the motions that are set for today. I was surprised by this motion for dismissal when I was handed it just a few moments ago. It's because the other motions were filed back in 2022. This motion was filed October 17th of 2023. Today's the 19th, so 2 days ago. That's why apparently it was not, I did not have it, but that's why I'm asking the question, because I want to know when the court was aware that there was going to be an issue in regards to this speedy trial.
And again, I think I agree with the state. I can't remember what was discussed at the status conference. We did not file a motion to dismiss at the time of arraignment almost 2 years ago, because it wasn't really ripe at that point. It ripened after that, but most certainly the prosecutor's office was aware that we asserted the right way back in September of 2021.
I'm not trying to place blame on anybody, Mr. Sullivan. I'm just trying to get a perspective for the court as to whether you did or the state made the court aware that that there was going to be this issue.
I don't recall. I don't recall the court actually being made aware of it until I actually filed the motion to dismiss.
Okay. I'll take it under advisement. I'll look at the cases that you'll have presented.
Thank you, Judge.
Okay. Are we ready to proceed with
Yeah.
with the other motions?
And I think, Judge, for the motions, and counsel to help me out, I believe it's just a probable cause and implied consent, voluntariness,
Yeah, and it's not, we have a constitutional.
but the constitutional argument.
Like I said,
Yeah.
We filed 2 motions on that.
Okay, I have those.
Okay. And Judge, with that, in terms of the probable cause, I'll go ahead and call Officer Lambert to the stand. Officer Jackson, do you want to step out and hold?
Swear from testimony about giving the case to be the truth, the whole truth, and nothing but the truth.
I do.
Thanks. Please state your name.
Daniel Lambert,
Good morning, Officer Lambert. How are you currently employed?
with the city of Alpharetta as a police officer,
How long have you been employed in the city of Alpharetta?
23 years.
Prior to your employment with Alpharetta, have you been employed with any other law enforcement agencies?
I was employed with the Aiken County Sheriff's Office in South Carolina for 4 years,
So how many total years have you been in law enforcement?
27.
And are you post-certified?
I am.
Were you post-certified on June 6, 2021?
I was.
What type of training have you had in terms of DUI investigations or DUI training?
I've had the 24-hour field sobriety training. I've had an 8-hour drugs and impaired driving training. I've had the 16-hour A-ride training. I'm a certified DRE for the state of Georgia, and I'm an instructor in field sobriety and DRE.
Okay. And are you up to date on all of the certifications and trainings for DRE, A-ride, and field sobriety?
Yes, ma'am.
And were you working with Alpharetta on June 6, 2021?
I was.
And were you called out to an accident scene about 8:50 p.m. that day?
Yes.
Okay. And can you tell the court a little bit about what you observed in terms of the accident that occurred that day when you responded?
Yes, ma'am. When I responded, it was on West Side Parkway near Gardner Drive. The car actually ended up at the intersection of Gardner Drive. It was a black Tesla that had flipped over, single vehicle accident. I pulled up and blocked the roadway, started talking to the occupants that were still in the car, and realized that a couple of the occupants may have serious injuries. Fire EMS showed up. They said there was a possibility, so the traffic unit was called.
Okay. And did you make contact with the driver of that vehicle?
I did.
Okay, and when you made contact with the driver of the vehicle, what did you observe, if anything?
I know she had bloodshot or very glassy eyes. She had the odor of an alcoholic beverage coming from her breath in person. She seemed to be dazed and confused. Really couldn't complete a sentence hardly. When I asked her what happened, she said we were just driving along and the car just wrecked.
Okay, and do you see that person who was the driver of the vehicle that evening in the courtroom?
I do.
And where is that person?
Sitting here at the table wearing a black jacket and a white shirt.
Okay, thank you. And based on those observations that you just testified to, so the odor of alcohol, the glassy eyes, and slurred speech, what did that indicate based on your training and experience?
I let the officers that came to the scene know that the driver was possibly under the influence of alcohol.
Okay, and did you talk to, did she tell you where she was coming from?
She did. She said she was coming from the Avalon area.
Okay, and what is the Avalon area?
It's a shopping / restaurant area for Alpharetta.
Okay. And did you talk to any witnesses on the scene?
I did not talk to any witnesses on scene.
Okay. And was the defendant, or excuse me, was the driver of the vehicle who you just identified, were they transferred to the hospital?
Yes, all occupants of the car were transferred.
Okay, thank you. No further questions for this witness at that time, Judge.
So,
Thank you, Judge. This was a significant accident, right?
Yes, sir.
The vehicle, tell me if I'm wrong, it appears from the evidence on scene that it rolled multiple times.
That's correct.
And a tree may have been struck as well.
I believe the tree was clipped. The car went up into the median and came back out and started rolling over.
Was she still in the vehicle when you arrived?
Yes.
Okay. Airbags deployed,
Yes, sir.
broken glass.
Yes, sir.
You recall how soon, now this section of roadway is very close to the police headquarters, is that correct?
Yes, it was.
You recall whether you were coming from police headquarters to respond to this accident?
I was not. I was coming from down around the mall area,
Mall,
North Point Mall area.
still very close, right?
Yes.
About 5 minutes,
Yeah, depending on red lights, 5 to 10.
and emergency equipment too.
Right.
Okay, probably 3-4 miles.
Or yes.
In your interaction with Ms. Stanner, was it just while she was in the vehicle, then EMS took her out and transported her on?
That's correct. I was down in the window because it was still on its side at that point, and I was talking to her through the window
Okay,
of the car.
now, you've done accident reconstruction work, have you not?
Yes, sir.
And you can tell the court, or you agree with me that the forces of an accident can disorient people, is that right?
To a point, yes, sir. Sometimes.
And potential head injuries as well?
Yes, sir.
When she had a cut and bump over her eye, is that right?
She was bleeding on it from her face.
Okay, all right. And you indicated she had an odor of an alcohol beverage. Do you recall whether that was a strong odor, mild odor, or just an odor?
Just an odor. It doesn't matter if it's strong or weak.
Okay.
I mean,
And just from your NHTSA training tells you just from the odor alone, you can't tell how much someone had to drink, right?
correct. That's why I don't do strong or weak.
Okay, okay. And you did not follow Ms. Stanner to the hospital to continue your investigation?
No, sir. I was blocking the roadway.
You were the supervisor that day, right?
No, sir. I was just a road officer.
Okay.
I just moved back to the road from traffic, so I was no longer in traffic.
I don't have any further questions, Judge.
redirect? No,
Nothing further.
thank you, appreciate it. Call your next witness.
Whatever you want. You good? Okay. Is he okay to be excused, Your Honor?
Yes,
Okay.
have a
Thank
good
you.
day.
Will you tell, the state will call Officer Thaxton. Lambert, can you tell Thaxton to come in? Thanks. Oh, if you have it in for the record.
Yeah.
You good? Okay.
Do you have a copy of that? And then I might use that on cross, just leave it on the table.
Yeah, I'll send it to him.
Short-term testimony about giving the case for the truth, whole truth, nothing but the
Yes, I do.
truth.
Anthony Thaxton.
All right, thank you, Officer Thaxton. How are you currently employed?
Currently I'm employed with the Forsyth County Sheriff's Office.
And how long have you been employed with Forsyth?
About 15 months now.
What's your position there?
Currently I'm assigned at a detention center.
Okay, and prior to being employed with Forsyth, were you employed with any other law enforcement agencies?
Yes, ma'am. I was employed with the Alpharetta Police Department immediately prior to Forsyth County.
Okay, and prior to Alpharetta, any other agencies?
I work for the Ringgold Police Department and the Duluth Police Department as well.
Okay,
Past.
how many total years have you been in law enforcement?
This is my 12th year.
And are you post certified?
Yes, ma'am.
Within your career as a law enforcement officer, what type of training have you had when it comes to DUI?
In addition to the standard training that we received in the police academy, I've also been through standardized field sobriety class, the AVI class, and recently I did complete the DRE class.
Okay, so you, in your A-RIDE training that you're certified in, do you guys do wet labs?
In ARIDE, we don't do wet labs, but there are wet labs in the standardized field sobriety class.
Okay, and so you said your field sobriety is certified, A-RIDE and DRE.
Yes, ma'am.
And what is DRE, just for the record?
DRE stands for Drug Recognition Expert.
And are you up to date on all of your certifications for those different types of trainings?
Yes, ma'am.
And while you were with Alpharetta, let me rephrase that. Were you with Alpharetta Police Department on June 6, 2021?
Yes, ma'am.
What was your position then?
At that time, I was assigned to the DUI task force within the traffic unit with the Alpharetta Police Department.
Okay. And during that time period, were you DRE certified or just A-RIDE?
Just ARIDE at that time.
Just A-RIDE. So A-RIDE and field sobriety certified on June 6, 2021.
Yes, ma'am.
Okay. Were you working a shift on June 6, 2021?
I was actually on call that evening for the traffic crash response team.
Okay, and what's the traffic, when you say on call for that, what does that mean?
So the traffic unit itself has assigned teams that investigate serious accidents that may involve injuries. And I was assigned to part of the team that was on call that evening. So when I received the page to come in, I was activated to come in to work, assist work in the accident.
Okay, and on June 6, 2021, were you called in to an accident?
Yes, ma'am.
Okay, and where did you, if you can recall, where did you respond to that accident?
So initially I responded to the crash scene itself on West Side Parkway near Gardner Drive, where I met with Officer Frank, who's the team leader for our accident investigation team.
Okay, and when you arrived on scene, what did you observe, if anything, about the scene?
So the scene itself is pretty large. I noticed that there was an overturned vehicle that appeared to have traveled across the median and overturned, and there was a lot of debris scattered across a large portion of the roadway.
Okay, and did you talk with Officer Frank?
Yes,
about what happened?
Yes, ma'am.
Okay, and what did he advise you?
He said that they had a single vehicle.
Judge, I think he objected to hearsay. My response would be this is a probable cause hearing. He was the arresting officer for the DUI, and so it goes to probable cause and we're in a motions hearing.
I'll allow it. Go ahead.
Officer Frank informed me that there was a single vehicle accident that resulted in what they believe to be some serious injuries of the driver and the occupants, and that Officer Lambert, who was also on scene at that time, stated that he had spoken to the driver before she had been transported to the hospital, and that they believe that there was odor of alcoholic beverage and her eyes appeared to be bloodshot.
Okay, and based on all of that information that you received on scene, what did you do?
So Officer Frank asked me to go to the hospital to speak with the driver, who was identified as Ms. Stander. So I went from the crash scene itself to Norfolk Hospital to speak with Ms. Stander.
Okay, and were you the only officer to go?
Yes,
to
ma'am.
the hospital?
Yes, ma'am.
And when you arrived at the hospital, did you go to the hospital room?
Yes, ma'am.
Okay. Who was in there with you, if you can recall?
Ms. Stander was in the bed in the hospital room, and there was another gentleman which she identified as her boyfriend. I don't remember his name, unfortunately, but there was another male there that she identified as her boyfriend.
And you were the only officer?
Correct.
And when you got there, did you identify yourself?
Yes, ma'am.
Okay. And did she confirm that she was in fact the driver of the vehicle?
Yes, ma'am.
And were you just openly talking to her at this point?
Correct. I informed her I was just there to investigate the circumstances of the accident. So I asked her a couple of questions about the accident.
Okay, and what did you observe about her, if anything, while you were talking with her?
So while speaking with Ms. Stander in the hospital room, I was still able to detect the odor of alcoholic beverage. And I was able to see for myself that her eyes did appear to be bloodshot at the time.
Did you ask her or inquire where she was coming from when the accident occurred?
Yes, ma'am.
And what did she respond with?
She stated initially that she was at Rumi's Kitchen in Avalon, where she had left there and went to another restaurant, which I believe she said she couldn't remember the name of at the time.
Okay, and did you ask her if she had anything to drink that night?
Yes, ma'am.
And what was her response?
She did say that she had 2 old fashions.
Okay, and what type of drink is that if you?
It's a whiskey drink, I believe.
Okay. And at that point, did you ask her to perform field sobriety evaluations?
No, ma'am.
And why is that?
Due to the fact that she had just been involved in that motor vehicle accident and was not completely sure of the extent of her injuries, so I did not attempt to perform any field sobriety.
So based on the extent of her injuries in the hospital, aside from that, did you make a determination how to proceed after talking with Ms. Stander?
Yes, ma'am. So after speaking with Ms. Stander and my observations at the scene of the accident, I believe that due to the fact that it was a single vehicle accident, there was no other vehicles that were involved. She stated that she had been consuming alcohol that evening. She was the driver of the vehicle, and that I was still able to detect the odor of alcohol beverage while speaking with her. That established probable cause for me to inform her that she was going to be placed under arrest for DUI.
And were her bloodshot watery eyes also an indication?
Yes, ma'am. I'm sorry. Yes, the odor of alcohol and the condition of her eyes being bloodshot and watery.
And when you say you placed her under arrest did you tell her that she was under arrest?
So that specific circumstances, I informed her that she was going to be placed under arrest, but I wasn't taking her into my actual custody due to her being in the hospital. So I informed her at that point that she was under arrest, not free to leave, but I wasn't actually putting her in handcuffs and taking her anywhere.
And what did you arrest her for?
She was arrested for DUI.
Okay. And after you told her that she was under arrest for DUI alcohol, did you read her implied consent?
Yes, ma'am.
Okay. And I'm going to show you what's been marked as state 1. Are you good to just defense counsel and I have stipulated the implied consent part will be admitted into evidence.
Objection.
And
Yes.
I'm going to show you what's been admitted and marked as state 1. Is that the implied consent card you read that evening to Ms. Stander?
This is a copy of the implied notice that I read. Yes, ma'am.
Okay, and is that the same copy that you read to her that night?
Yes, ma'am.
And what section of the implied consent card did you read to her?
So I read her the Georgia implied consent notice for suspects age 21 and over.
Okay, and approximately how quickly after you told her that she was under arrest for DUI did you read that?
Within minutes. I don't have an exact time frame, but I informed her that she was under arrest, and then I informed that the next time we discussed was that I was going to read her the implied consent notice.
And you were able to determine her age was over 21?
Yes, ma'am. With her ID driver's license, I was able to determine her age of being over 21.
And did you read that card, the section for the implied consent for over 21? Did you read that card verbatim?
Yes, ma'am.
Okay. And what was her response when you read implied consent?
So Ms. Stander initially stated she didn't know what to do. She tried asking me some questions, asking me what she should do, and I informed her that I wasn't able to give her any advice on what she could or couldn't do. I offered to read her the card again if she was unsure of what I was asking, but that I couldn't give her any advice and I just needed a yes or no answer from her.
Okay. And when she asked you, when you read the card and she asked you, was asking you a question, did you advise her in any way about what was included on the implied consent?
No, ma'am.
Did you give her any advice on how to answer one way or the other?
The only thing I told her was I just needed her to give me a yes or no answer.
Okay. And did you threaten her in any way to get her to do the implied consent to the implied consent?
No, ma'am.
Did you coerce her in any way?
No, ma'am.
Did you give her any promises of leniency saying, if you do this, then I'll do this?
No, ma'am.
And do you think that she understood what you were asking her? And that you think she understood, comprehended what was on that implied consent notice?
I believe she did. She asked me to read the card again, which I read verbatim to her a second time. And after that, she was able to give me an answer. So I believe she understood.
Okay. And during your whole encounter with her, when you went to the hospital, because I know she was involved in an accident, was she like coherent to have conversation with you?
Yes, ma'am. I believe she was.
Okay. And when you, so did you reread the implied consent card to her?
I read it the second time. Yes, ma'am.
Okay. And what, state test did you ask her to consent to?
I requested a state blood test.
And did she agree?
Yes, ma'am.
Okay. And did she get her blood drawn that, while she was in the hospital?
Yes, ma'am. While I was still present.
Okay. And, at any point, did you think that her consent to a blood test was not voluntary?
No, ma'am.
Did she do or say anything that made you think her consent wasn't voluntary?
No, ma'am.
At any point, did she ask for an independent test?
No, ma'am.
If she did, would you include that on your report?
Absolutely.
No further questions at this time, Your Honor.
Ross?
So you can redirect.
Thank you, Judge. May I approach the witness to get the implied consent? Officer Thaxton, you're with Forsyth County. I couldn't hear you quite clearly. You're not a road deputy. You work at the detention center.
I'm currently assigned to the detention center. Yes.
What are you doing at the detention center?
The detention center is basically the jail. We keep track of the inmates that are incarcerated at Forsyth County Jail.
Okay, and you worked at a few other places before you went to Forsyth County, is that right?
That's correct.
Okay, Duluth Police Department,
Yes,
okay, and you resigned in lieu of termination from Duluth Police Department, is that right?
that's correct.
Okay. Ringgold Police Department after that,
That's correct.
okay, you voluntarily resigned from that department, right?
That's correct.
Okay, and then in this case, you were working with Alpharetta Police Department, is that right?
That's right.
And you're flat out terminated by.
Your Honor, I'm gonna have to object at this point. This is a probable cause hearing. And I don't think what he's getting into is relevant. And I think it's improper.
I'm gonna give him some leeway. Go ahead.
Okay.
Judge, it goes to his credibility.
Okay, go ahead.
You were terminated by Alpharetta Police Department, correct?
That's correct.
And the reason for that is for your excessive speed in police pursuits, correct?
No,
And Judge, I'm gonna have to just object for the record. There's not allowed to be a general attack on credibility. If he's going to ask anything about it, it has to be something that goes to his truthfulness. So I'm gonna object just for the record.
I'm gonna let him lay a foundation.
Okay.
which is what
I'll
I
move
think.
on, Judge.
Okay.
So you responded to West Side Parkway and Gardner Drive on June 9th of 2021.
that's correct.
You were in your uniform,
Yes, sir.
patrol vehicle,
Yes, sir.
body camera,
Yes, sir.
and the vehicle had a camera as well, correct?
Correct.
Okay. And you were, Ms. Stander was already gone from the scene, correct?
Excuse me. I'm sorry. Correct.
You just received information and you were directed to go to North Fulton Hospital, right?
That's correct.
Was Ms. Stander in the emergency room?
Yes.
When you're on scene, did you see the vehicle?
Yes.
Okay, it's safe to say it was apparent that it struck a tree and rolled over several times,
Correct.
airbags deployed,
Yes.
pieces everywhere, right?
Yes.
It was a pretty significant accident.
Correct.
Right, okay. And when you respond to North Fulton Hospital, she was in the emergency room?
Yes.
Okay. And you did not turn on your body cam?
Body camera would have been on. Body camera would have been on.
Would have been on?
Yes.
So you're saying there is a body cam somewhere?
There should be. I don't have any of those records, but I have my body cam on at the time.
Okay. Now, when you observed her, you observed a cut and swelling above her left eye, correct?
That sounds right. Yes, sir.
And that's consistent with her head banging against something during this violent crash, correct?
I would assume it came from the crash, yes.
Okay. It concerns you enough that you elected not to do any field sobriety evaluations, right?
That's correct.
And your field sobriety is certified, and part of that training, the NHTSA training goes into the horizontal gaze nystagmus evaluation, right?
Yes, sir.
And you're concerned about head injuries.
Sure. Yes, sir.
And that's the reason why you didn't do that evaluation either, right?
Correct.
Okay. And do you recall how soon after the collision that you responded to Norfolk Hospital?
I don't have the times, unfortunately, and what time I arrived at the hospital. So I would say probably my best guess would be an hour if I had to make a guess.
This is a pretty traumatic experience when someone undergoes an accident like that, correct?
I guess so. Yes.
Okay. And she was being treated?
There wasn't a nurse in the room at the time I get there, but they were in the process of giving her treatment. Yes.
And injuries near or swelling near an eye can cause bloodshot and watery eyes, correct?
It's possible.
Okay. Now you indicated you noticed an odor of an alcohol beverage coming from her.
Yes, sir.
Your NHTSA training tells you that odor itself doesn't have alcohol itself doesn't have an odor. It's the beverage itself that contains the odor, right?
Right.
And do you recall whether it was strong, mild, moderate?
I don't typically try to quantify it just because individuals have different levels of quantification. So either for me, either this odor was present or not present.
And that's the point, right? Is you can't tell how much someone had to drink just based on odor alone, right?
Yeah, of course. Yes.
Now, you read the Georgia implied consent notice to Ms. Stanner, right?
That's correct.
Okay. And my eyesight is pretty bad, but I'm going to try to go over this with you. This is the language that the Georgia legislature lays out that you're required to read to somebody, correct?
Yes, sir.
Okay. And a specific language, right?
Yes, sir.
Okay. Now, beyond that, you're actually trained not to give information beyond the notice itself, right?
That's correct. We're told just to read the notice as is.
Although you most certainly know a whole body of law on what the notice is about, correct? Just from your training surrounding the implied consent notice.
I'm not sure.
Okay, I'll walk you through the notice.
Okay.
Now, part of this essentially states, and you can tell me if I mess it up, right? The state of Georgia has conditioned your privilege to drive upon the highways of this state upon your submission to state administered chemical tests of your blood, breath, urine, or other bodily substances for the purpose of determining if you're under the influence of alcohol or drugs. Now, the second part and you read this clearly to her, right?
Yes, sir.
Okay. Word for word?
Yes, sir.
Okay. If you refuse this testing, your Georgia driver's license or privilege to drive on the highways of this state will be suspended for a minimum period of 1 year. Your refusal to submit to blood or urine testing may be offered into evidence against you at trial. You read that to her, right?
Yes, sir.
Actually read that to her twice.
Yes, sir.
Okay. That her refusal to submit to blood and urine testing would be offered against her, may be offered against her at trial, right?
Correct. As part of the notice. Yes.
Okay. Now, the next paragraph, if you submit to testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. You read that to her, correct?
Yes, sir.
You're familiar with, well, are you certified to run an intox machine?
Yes, sir.
Okay. And you have a choice, of course, as to, what test to give Ms. Stanner, right?
To some degree, yes, sir.
Blood, breath, or urine.
Correct.
Now, this notice says 0.08 grams or more, right? It says that right in the notice.
I don't have it in front of me, but if that's what it says, I believe you.
Okay, I'll read it again to you, just make sure we're on the same page. If you submit to testing and the results indicate an alcohol concentration of 0.08 grams or more, your Georgia driver's license or privilege to drive on the highways of this state may be suspended for a minimum period of 1 year. Is that correct?
Yes, sir.
Okay. 0.08 grams per what?
Depends on the test.
Do you know?
I'm not sure. I'm understanding what you're asking. Grams of,
I'm asking you, that's what the notice, that's all the notice says.
Okay.
Per what?
it's a reference to the amount of alcohol, I guess, that they would determine is in the bloodstream or the breath, depending on what type of test that we request.
Is there a quantification of volume listed in that notice?
Your Honor, I'm gonna object. I think we're outside the scope of what the officer can testify to. And also relevancy, we're here for probable cause.
Judge, this is part of an implied consent issue, so I'd like to have a little bit more leeway in this, and this will become apparent in my argument.
If he doesn't know, he can just say, I don't know.
You don't know, right?
I don't know.
You didn't tell her either.
No, sir.
Okay. Now, towards the last part of the notice, it says after first submitting to the requested state test, you're entitled to additional chemical tests of your blood, breath, urine, or other bodily substances for the at your own expense and from qualified personnel of your own choosing. You read that to her, right?
Correct.
Now, the prosecution on direct asked you, did the Miss Stander ever ask for an independent test? Is that right?
That's right.
Does this notice have any language anywhere in there about an independent test?
Yes. Well, that is what that language means. You have the right to have it tested at your own choosing.
Is the phrase independent test in this notice?
It's not in the notice, I don't believe.
Okay, it's not. And she had questions for you, right?
She did.
About this notice. She asked you several times about this notice, had questions for you.
Yes.
And your response was, I can't give you any information beyond what's in this notice.
That's
correct. She was conferring with her boyfriend as to what to do.
Correct.
She didn't know what to do, right?
That's what it appeared at first, yes.
Okay. Now, you decided to read the notice to her again, correct?
Yes.
Same way, right? Didn't change anything, right?
No, sir.
Okay. And then again, no guidance to her as to what to do.
I'm not allowed to, so no.
Okay, all right. And faced with that, she agreed to submit to your test.
Yes, she made her own decision to agree to the test.
One moment, Judge. But when you read it the second time, and you can refer to your report, there was a few moments before she actually responded. She did not respond right away, correct?
Sure. Yeah, she thought about it.
But I'm sorry, what's that?
She thought about it before she answered yes.
Thank you.
No, you can share it. Are you finished? Yeah, I don't think I have anything else. I don't think I have anything further for this officer, Your Honor.
Okay. May you be dismissed?
No.
Thank you. Have a good.
Yes, sir. Thank you, Judge.
Any other witnesses?
No, nothing from the state, Your Honor.
Judge, I'd like to recall Ms. Stander to the stand.
Okay.
Now, Ms. Stander, you've been previously sworn during this hearing to testify, is that right?
Yes,
Okay, now, I'm gonna zoom right in to where you were in the emergency room, okay? And just make sure the court reporter actually takes down the proceedings, so just verbally respond when I
Oh,
ask you
yes.
questions.
Okay.
Now, you're in the emergency room?
Yes,
Okay, and your boyfriend was in the emergency room with you?
yes, he was.
Okay, at some point, Officer Thaxton appeared.
Yes.
Can you explain the circumstances or what happened once he appeared to the emergency room?
Once he appeared, I was in the bed. I think my wrist was still bleeding. Trying to remember. When he started to read the implied consent notice, like he said, I didn't know what to say, didn't know what to do. I asked my boyfriend, he tried to Google it. asked questions. He wasn't able to give me any answers to that. So I had to try and make a decision, and the two things that very heavily weighed into feeling like I had no choice but to take the test was the license suspension. I need to drive, I need to get to work, I need to get my children where they need to be. And then the second part was that if I did refuse, it could be used in court, and didn't need additional things against me in court. So felt like I didn't have a choice. I had to do it. There was no other option.
Did the officer at any point give you any guidance apart from just reading the notice to you?
No, he seemed to get a little agitated that I was asking him for guidance. But other than that, no. He just said yes or no is what I need.
Did you really fully comprehend what was being read to you?
I don't know if I understood the full implications. I did ask to speak to a lawyer, was said I couldn't. Just didn't feel like I had a choice. I had to do it.
That's all I have, Judge.
The standard, did Officer Thaxton threaten you in any way?
No, he did not.
Did he yell at you in any way?
No, he did not.
Did he coerce you in any way to choose one way or the other?
He was just very adamant that he needed a yes or a no.
So he gave you a choice. You could either say yes or no.
Correct.
Okay. And did he make any promises to you one way or the other, whether you would consent or whether you didn't want to consent?
No, he did not.
So you would agree with me, the choice was yours entirely to choose yes or no to the implied consent?
Yes.
Okay. No further questions, Judge.
Anything further?
Sorry, Judge.
Thank you.
Thank you, Judge.
Anything further?
I have no further witnesses, Judge.
Okay, argument?
Yes, Judge. In terms of argument for probable cause for arrest, the state has satisfied that there was probable cause for a DUI arrest. You have Officer Lambert's testimony that he responded to a single vehicle accident. The defendant was the driver. The defendant, when Officer Lambert made contact with her on the driver's side door, when he was talking with her, he smelled the odor of alcohol, bloodshot, watery eyes, she had blurred speech. That was the testimony today. In addition to the car accident itself and the observations, Officer Thaxton then reported to the hospital where he also observed the odor of alcohol, the bloodshot, watery eyes, and the defendant's own admission to drinking at least two liquor drinks before she drove. And that in and of itself, Your Honor, it would be probable cause to arrest for DUI. The case I will rely on is Gillum v. State, 295 Georgia App 358. And that just basically states law enforcement had probable cause to believe the defendant was driving under the influence of alcohol so as to justify a chemical test of the defendant's blood for alcohol when the officer detected an odor of alcohol on the defendant's breath and the defendant had a collision with another vehicle by his unsafe act of failing to yield. So in Gillum, they said there was probable cause for arrest when there was a car accident and an odor of alcohol on the defendant's breath. Here we have those two things in addition to the bloodshot, watery eyes, the slurred speech, the admission to drinking. So the state would ask you to deny the defendant's motion for probable cause. In regards to the implied consent notice, Judge, I don't think there's any challenge to which one was read. The correct implied consent was read. It was read immediately after arrest. You heard the testimony from Officer Thaxton that he didn't place her in traditional custody, obviously because she was in the hospital, but he did tell her, you are under arrest for DUI. He subsequently read the Georgia implied consent notice, the correct notice, which was in effect at the time of this incident. And he the state is satisfied in terms of voluntariness, that she voluntarily agreed to it. You heard Officer Thaxton's testimony. All he did was read the implied consent card. He did not advise her. He did not coerce her. There was no promises of leniency, nothing. In the defendant's own testimony on cross-examination, she said, yes, it was her decision, yes or no. So in terms of voluntariness, the state has satisfied that. And I believe the defense is going to have a challenge to the constitutionality of the implied consent notice in and of itself. Judge, this was the implied consent notice that was in effect at the time. The case law on implied consent, we know, is somewhat ever changing. I know that there's issues up in the Supreme Court right now about the implied consent, but what's important is that this was in effect at the time of the arrest. This is exactly what the officer read. This is what the law is. And Olivic and Elliott have already held the implied consent notice in and of itself is not wholly unconstitutional. And so for those reasons, I would ask that you deny the defendant's motion to suppress for probable cause and deny the motion to suppress for anything to deal with implied consent.
Thank you.
Thank you.
Sullivan?
Judge, I know you understand pretty well DUI law, especially jumping into your role with Orca, handling cases, and you actually had a trial or so in this past year. It helps to put this in context of the history of the case law with regards to the voluntariness aspect, as well as the constitutionality of the notice itself. And really at the heart of it starts way back in Schmerber versus California. And that is 384 US 757. That's a 1966 case. My memory is a big vague, but I believe Mr. Schmerber was involved in a car accident. Officers suspected that Schmerber was DUI. Wanted him to just voluntarily consent to a chemical test. He said no. And rather than getting a search warrant, the police just simply got someone that's qualified to draw blood and drew blood out of Schmerber. And of course, comes back with bad stuff in it. Schmerber's attorney challenged that case on Fourth Amendment grounds. The court allowed the test in under what's called exigent circumstances. And so Schmerber's attorney challenged the case all the way up to the United States Supreme Court in that law enforcement should have gotten a search warrant in that circumstance. The US Supreme Court in Schmerber said that because of exigent circumstances, no warrant was needed and they were allowed to draw blood. From my reading of Schmerber, and I'll go over the cases that follow after, the United States Supreme Court could have probably done a better job in drafting its Schmerber opinion, because after Schmerber, it was interpreted by just about every state in the country that there's exigent circumstances in every DUI case, because alcohol dissipates from the body rapidly, and didn't need a search warrant, or it is yet. Then comes the implied consent notice statutory scheme, not just here in Georgia, but it developed throughout most, if not all, of 50 states back in 1968. And I believe the public policy was to find some better way to coax someone to submit to the test without having to get a search warrant. And all the way up until 2013, it was the general understanding of the Georgia Court of Appeals and the Georgia Supreme Court that defendants simply had to take a test, although they had implied consent right to refuse, facing the consequences of a license suspension, but they essentially had to take a test. As a matter of fact, the notice back then basically says Georgia law required you to take the state's test. That was the understanding, not just here in Georgia, but basically everywhere across the country. Then comes Missouri versus McNeely that came out in 2013. And that's 568 US 141. That's a United States Supreme Court case. McNeely was, of course, arrested for DUI in Missouri. The officer in Missouri read its version of the implied consent notice, and Mr. McNeely declined to voluntarily consent to the test. Rather than get a search warrant, the officer simply took Mr. McNeely to a local hospital and had a nurse draw blood. McNeely challenged successfully in the state court there, including the state Supreme Court of Missouri, that in that circumstance, exigent circumstances didn't fly. That there was an ability to get a search warrant, the officer didn't avail himself to it, and the test is out essentially. So the state, not being happy with that, appealed it to the United States Supreme Court on the exigency issue. And what the United States Supreme Court essentially said in 2013 is yeah, there's three ways to get a sample out of someone. There's voluntary consent. There's go to a magistrate or judge to get a search warrant if there's sufficient probable cause, or exigent circumstances. What they held on the last factor, exigent circumstances, they essentially admitted that y'all got this murder case all wrong, and not every DUI cases are exigent circumstances. As a matter of fact, that's a rare occurrence because magistrate judges are so readily available 24 hours a day in most jurisdictions. A lot of places have telephonic warrants, video warrants. It's easy to get. So exigent circumstances become a rare thing. So that was ground shaking. And of course, once the US Supreme Court issues a decision, it takes time to filter down into state case law. And it most certainly did here in Georgia in a case called Williams versus the state. It's a seminal case in DUI case law that is 296 Georgia 817. I believe it came out in 2015. Williams focused in on the voluntariness aspect pursuant to the notice that was in effect at that time. And not dealing with search warrants and not dealing with exigent circumstances, just voluntariness aspect. And what Williams essentially said that any time that a court considers the admissibility of a chemical test, there's a two-part test that you must undertake in an analysis to determine whether a chemical test is admissible in any trial. And the Williams case essentially said, step one, was there actual consent? That's step one. If there's no actual consent, you don't get step two. That's the end of the analysis. And what's mentioned in Williams is just agreeing or saying yes, the test doesn't end the analysis for the court. The court has to look at the totality of the circumstances to see whether that's actual consent, and then factor that into the second part of the test. Was that consent voluntary? All right, that's the two-part test. So in this case, she is in a hospital bed, told that she's under arrest, undergoing treatment from a significant accident. She had questions, multiple questions, that went unanswered. Can't answer. Just read the notice in. How do I call a lawyer? No, you have no right to a lawyer. And by the way, on that point, there is a case called Rakoff versus the state. It came out in 2006 that essentially says that's not a critical stage of the proceeding. I'm sure the state will look that up. And that a defendant has no right to talk to a lawyer at that point. No right to do that. That does not prohibit an officer giving someone an opportunity to call a lawyer. She asked if she could call a lawyer, even though she doesn't have the right. She was trying to understand this notice, and she was denied that ability. She was stuck talking to her boyfriend as to what to do. And then the notice was read again, non-responsive to her questions and concerns. And the notice itself has its issues, which I'll talk about a little bit later when I get back into the constitutional part of things. The big part of it is if you refuse to blood or urine testing, that may be used against you at trial. Well, the notice used to say breath, blood, and urine. That could be used against you at trial. Elliott came down in 2019, and that is Elliott versus the state, 305 Georgia 179. That's a 2019 case. Mrs. Elliott was arrested for DUI in Athens, Georgia. She was read the implied consent notice at that time for breath. She refused. The prosecution, pursuant to the Georgia statute, wanted to use that refusal against her at trial. The defense wanted it kept out. What the defense argued successfully is that Elliott exercised a very important constitutional right, the right to refuse under the Georgia Constitution. And when someone exercises that right, that can't be held against them at trial. So that decision, I believe, dropped in February of 2019, right in the middle of the Georgia legislative session. And then in the Elliott decision, there's some concurring opinions that did have some concerns about the notice itself. So the legislature actually did, in my opinion, did a rush job to correct what Elliott said was unconstitutional, that they can't a breath refusal against somebody at a criminal trial. They didn't bring it up. But what they left in the notice is the blood and urine. If you refuse those, that may be used against you at trial. Then comes AWAD versus the state. I believe my spelling, I'm sure, is wrong. That's AWAD 313 Georgia. I'll have to get that back from the judge. My handwriting is terrible. Georgia 99 is a 2022 case. That dealt with a urine test. And AWAD essentially said that Georgia Constitution provision provides, it also applies to urine test refusals. If someone refuses a urine test, they can't use that against them in a criminal trial as well. That's still in notice. They haven't addressed, the legislature hasn't addressed that yet. It's still there. Unconstitutional. Person's told it could be used against them at trial. Now, getting to the heart of the matter with blood tests. So after Williams versus the state, it's really a groundswell of the Georgia Supreme Court and the Georgia Court of Appeals taking a look at the DUI case law anew in light of the Missouri versus McNeely case. Where before everybody thought for years, 47 years, that defenses had to submit to a test. Well, after McNeely, everything changes. And then starting with Olevik versus the state, that's OLEVIK, 302 Georgia 228 2017. As a breath test case, that the Georgia Supreme Court for the first time applied this very old Georgia Constitution provision around since the 1860s to DUI. Very first time ever. And essentially says a person has a right to refuse to submit, to be compelled to submit to an act, and a breath test is an act that they can refuse. Then Elliott follows up that if they exercise that right to refuse, that can't be held against them at trial. AWAD says the same thing for urine refusals. And more recently, just last fall, in November of last year, in Ammons versus the state, I don't have the official site, but I do have the Georgia Supreme Court case numbers S22A 0542. The Supreme Court expanded that to pre-arrest portable alcohol sensors in field sobriety evaluations. So the Supreme Court is tilting towards the defense in exercising these very important rights. State versus Randall came out in 2022. That's 315 Georgia 198. Randall was arrested in Athens. The most current version of the implied consent notice, I believe, was read to Randall. The officer asked for a blood test, not a breath test, but a blood test. And Randall refused the blood test. And Randall made the argument that if the officer is asking someone to voluntarily submit without going to the hassle of getting a search warrant, they refuse that. The state argues that could be used against them in trial, and then when it's a statute that says that, and they wanted to do that. Randall said, no, again, in line with Elliott, if someone exercises that very important constitutional right, that can't be held against him in a criminal trial. Most certainly, if the prosecution or if the officer got a search warrant, a valid search warrant, and a person refused to submit pursuant to a valid search warrant, absolutely, that could be held against a defendant at trial. But refusing to voluntarily submit to a chemical test absent exigent circumstances, and there's no evidence of exigent circumstances here or a search warrant, that should not be held against someone at trial. So what happened in Randall, I hate creating a record like this, but the Supreme Court, my guess is they didn't really want to deal with the issue yet. And they had a question, and they sent the case back down to the trial court. And one of the, for a rehearing, essentially. And one of the issues that Randall, the Supreme Court wanted the trial court to address is this language, this refusal to submit to blood or urine can be used against your trial. Does that still a defendant's exercise of the constitutional right to refuse a warrantless search? That's what the Georgia Supreme Court, in essence, one of the things they wanted the trial court to look at is to address. So the trial court had a rehearing in Athens State Court, and the trial court once again agreed with Randall that it actually did have a chilling effect on a defendant's exercise of the constitutional right to refuse a warrantless search and suppress the blood test refusal. That case was appealed by the prosecution. It's currently pending in the Georgia Supreme Court. I believe briefs have been filed on that issue. I don't know whether oral arguments have been set yet, but I'm expecting that is coming in that case. And something to look at, that deals with under most circumstances, blood tests fall under Fourth Amendment rationale, not under the Georgia Constitution provision. But our appellate courts have dealt with this issue before. In Mackey versus the state, that's MACKEY 234 Georgia Appeals 554. That's a 1998 case. Actually, part of that case was for the DUI case, but it's also a possession case. They found drugs in the car. The Mackey refused to give voluntary consent to search the car, and that was one of the issues that the appellate court was dealing with. As a prosecution, that used it against Mackey at trial, and what the Court of Appeals said is they can't use Mackey's refusal to voluntarily submit to search against Mackey at trial. That was in 1998. Gardner versus the state, 255 Georgia Appeals 489. That's a 2002 case. This dealt with the probable cause to get a search warrant, and what the officers did in Gardner is part of the application for a search warrant to search the property. Is they did bring in the application process, the refusal for Gardner to consent to the search of one's property. And what the Court of Appeals, and this Mackey and Gardner under Fourth Amendment grounds, said essentially refusal to consent to search of one's property cannot be used to establish probable cause for a search warrant to issue. So, because it's a constitutional thing, they have a right to refuse that absent a search warrant. They have a right to refuse to submit to a voluntary search. The United States versus Runyon, RUNYAN 290 F 3rd 223. That's a Fifth Circuit 2002 case. Runyon is a very long decision, but part of that decision dealt with the refusal to consent to warrant a search of a, I believe it's a computer. And what the Fifth Circuit said, this is again a Fourth Amendment issue, refusal to consent to warrant a search may not be presented as evidence of guilt. United States versus Runyon said that in 2002. And in 2005, in Miley versus state, that's MILEY versus state, that's 279, Georgia 420, that's a 2005 case. Miley, I believe this was a homicide case. Miley would not consent in writing to the search of his home. And what the officers did is they added that refusal to consent to the search of the home and part of the warrant application process. The Georgia Supreme Court, our court, in a Fourth Amendment issue, said that refusal to voluntarily submit to a search of his home could not be used against Miley in the application of search warrant. What are they saying? When someone exercises that constitutional right, whether it's under the state's constitution to refuse to be compelled to submit to an act, like under Elliott and Bolovic, or a refusal under Fourth Amendment grounds to searches like house, car, computer, blood, all Fourth Amendment searches, our courts are telling us that that can't be used against them in court, whether it's at trial or an application of a search warrant, the same constitutional standard. The court is looking at all of these cases anew after McNeely. And in light of the trend that we're seeing, which is a rapid trend from Bolovic to Elliott to Ammons, AWOD, and now they're considering Randall, and these other cases which have already ruled on Fourth Amendment grounds, it is clear that she actually does have that right to refuse to voluntarily submit to a search of her blood, and that can't be held against her trial. Why does that matter? Because the statute in the notice says that it will be used against her at trial. And you heard her testimony. That was one of the factors, one of two factors. One was a fear of losing her license for a year. The other one was, if I refuse, you're going to admit that in the evidence against me in trial. And the body of the case law that's already there and what's trending now out of the Georgia Supreme Court and our Court of Appeals is that they can't do that. That's coercive. She had questions. They were not answered. Just saying yes doesn't answer, doesn't finalize the question. The court has to look to the voluntariness. Part of voluntariness is coercive or misinformation. And I don't mean the officer misinformed her on purpose. The notice misinformed her with something that's not valid. She has a right to refuse to voluntary consent. So from the evidence, we see that she did not voluntarily consent because she had questions of not being answered. And on top of that, she was giving wrong legal information in the notice. And so we'd ask that the court suppress her blood test in this case under Williams versus the state analysis under the statutory construction, as well as under a constitutional analysis. Thank you, Judge.
Anything further, Ms. Riser?
Yes, Judge. Just briefly, I think the case law is very clear. I know counsel laid out a lot of it, but the case law is very clear. Under Elliott Bolovic, the implied consent reading in and of itself is not unconstitutional, as well as I believe State v. Henderson and State v. Fofana v. State also say that the implied consent notice is not inherently coercive or misleading because it has that language about refusal in using a refusal in trial. And Judge, I know a lot of the case law says the refusal can't be used against you, like the breath and the urine. Obviously, we're there now. But this case is not about a refusal. This is about voluntary consent, right? And so what the state's position is Officer Thaxton did everything and read everything correctly. The defense testified that she voluntarily consented. She wasn't, and when you look at voluntariness, it's the totality of the circumstances. So the defense is claiming that Officer Thaxton read the implied consent and that is unconstitutional because they said blood and urine could be used against you. That in and of itself doesn't negate or doesn't make the implied consent notice as read not voluntary. The defendant testified that he never threatened her, never forced her, never coerced her, never did anything. She made the decision after being advised of all of the potential consequences, if you want to call them that, but the potential repercussions for if she consented, if she didn't consent, she made that decision. So just the fact that the implied consent that was in effect at the time of the offense said that blood or urine could be used against you doesn't make it not voluntary. And the defense harped on the fact that she had questions that went unanswered. She had, wanted to speak with an attorney. One, she's not entitled to an attorney at that point. But two, Officer Thaxton's not allowed to answer the questions because if he did answer questions, we would be here on a different argument. I'm sure if Officer Thaxton responded and said, well, this is what you can do with implied consent, or if he advised her in any other way, I'm sure defense counsel will be up here saying, well, you can't answer her questions because that's coercive. You're giving her misleading information. You can't argue, you can't advise her on anything. The card that was in effect was red. That's not an unconstitutional card. She voluntarily consented. And so based on all that, Judge, I'm asking you to deny the defense's motion. And yes, Judge, I'll leave it at that.
And just briefly, Judge, this statutory notice is exactly what the Randall case is currently considering right now. And needs to remind the court that when it was remanded down to the trial court, the Supreme Court, in looking at the statutory language of that notice, the part that says that your refusal to submit to blood or urine testing may be offering evidence against your trial, they had direction for the trial court. Does that language chill a defendant's exercise of the constitutional right to refuse a warrantless search? Chill a defendant's exercise of a constitutional right to refuse a warrantless search. She has a right to refuse a constitutional right to refuse a warrantless search. She has that right. She's being told that if she refuses it, that's going to be used against her at trial. This is actually stronger than someone that actually refused the blood test because it, in my mind, it didn't have a chilling effect because they thought about it. They agreed they elected to refuse anyways. Here, understand, she thought she had no choice because that's what it said. So it did have a chilling effect. That was part of her decision-making process. That's exactly what our Supreme Court is dealing with. And that's offensive to the Fourth Amendment. Listing all these cases, you have that right that all these other cases that listed to the court, you have a right to refuse to voluntary submit to search, absent a search warrant. And in all those cases, that can't be held against the defendant in an application for a search warrant or at trial. The Supreme Court's about to make that final step in DUI cases. They're hinting to it right now that they're going to make that final step. They've already made that final step under the Georgia Constitution. And we'd ask the court to make that final step. There's existing Fourth Amendment case law out there right now dealing with this issue. It's there. The courts have already ruled that they can't use it against the defendant. And to have a notice that says that will be used or may be used against your trial, and it did have an impact on her decision-making process, That's where it has a chilling effect on her constitutional right to refuse, right there. That's why that's the court to suppress the test.
Okay, thank you. You all have given me a lot of case law today. If you would not mind, anything that you want me to consider, if you'll get that to Ms. Smith, I'll be happy to look it over and consider it. I'm going to take it under advisement for both sides. If you all can do that by, let's say Monday, does that give you enough time just to get the cases together to,
If I could have a little bit longer, I mean,
no, yeah, sure. You just let me know. What would be a good time period for you, Mr.
Judge, being,
A week from today? Is that a week from today?
that'd be perfect.
Okay, so if you'll get me any case law that you want me to consider, I'll consider it. Get it to me a week from today. Once I receive that, I'll review everything and I will get you all an order out on it. Okay?
Thank you, Judge.
And just so I can perfect the record, while you all were speaking, I was handed information regarding the Orca calendar for the status calendar back on July 13th. I was the judge that handled that case, so just to let you all know that.
And Judge, in fairness to both sides, we just didn't.
Right, I understand. Nor did I, so. Okay, if there's nothing further, you all have a good rest of your day.
Thank you, Judge.
Thank you, Judge.
Okay, do we have any pleas that are ready before I take the next hearing? Do have Bobby Jones, are we ready? Okay, are we ready on that one?
Thank you.
Who's handling that for the state?
I am Judge.
Okay.
You're gonna come up.
One, or was it January 3rd? January 3rd? That's a date from, I thought Judge announced it. I apologize. I'll have to.
What's
that?
January 3rd of 2024.
Yes, no, yes, right.
This is,
Status.
Yeah, he's not.
sorry, Your Honor. I didn't know who.
No, you're fine.
You know, like, that's just like. Right. Yeah. Right over here. It's just super clear.
Yeah, she already filled out her.
Yes.
Good morning, Ms. Jones.
Morning.
Can you raise your right hand for me, please?
Yes.
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You can place your hand down. Thank you, ma'am. Ms. Waldrop?
Yes, Judge, the defendant is charged with one count of DUI less safe and one count of following too closely. We'll be proceeding on the charge of DUI less safe, which should be pleading to today. The state will tender a null process on the following too closely. With respect to the sentence, Judge, the negotiated plea is for 12 months to serve 24 hours, credit for time served of 24 hours, balance probated, for the defendant to pay a $300 fine, complete 40 hours of community service, risk reduction, and alcohol and drug evaluation, and any treatment being necessary, as well as one victim impact panel. Judge, I've spoken with both victims in the case, Ms. Luke and Ms. Buffkin. There was no restitution, outstanding restitution that is owed. And so with that said, counsel, do you stipulate to a factual basis, venue, and identification for purposes of the plea?
Yes, I do.
Nothing further from the state judge.
Any objection to probation going non-reporting upon completion?
No, Your Honor, this is a first offense.
Okay. Yes,
Yes, Judge, we would ask that the court accepts the negotiated agreement, allows probation to go non-reporting after the conditions have been completed. And Your Honor, Ms. Jones has been struggling financially. She has completed the victim impact panel, begun her community service, and has scheduled her drug and alcohol evaluation, though she has not been financially able to get that done up to this point. We would ask the court to consider waiving the first 3 months of probation fees to allow Ms. Jones an opportunity to put that money towards the risk reduction course and the other fines and fees associated with getting her license back. She does still have 2 young children that live with her and is responsible for driving them. So she is going to be in a bind and is looking forward to getting this taken care of, but the financial hardships are extreme in this case.
okay. Ms. Jones, it's my understanding that in case 21 CR 0027688F, you wish to plead guilty to DUI less safe. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
I am not.
You've been represented by counsel. Are you satisfied with her representation?
I am.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
Yes.
Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated. Ms. Jones, I will waive 3 months of probation fees to help you get and stay on your feet. Once you complete the terms of the probation, it'll go to a non-reporting status. So the sooner you get it done, the sooner you won't have to report to probation, and the sooner you won't have to pay those probation fees, okay? I have already signed the first conviction. We will give you, if we haven't already, where you need to report for probation. I ask that you report within the first 2 weeks or so, okay?
Okay.
All right, any questions?
No, sir.
All right, good luck to you, ma'am.
Thank you.
Thank you, Judge.
And if you all get that null process, I'll include it with the paperwork here. I believe the last, yes. Ms.
I'll conclude my business.
Okay, yes, have a good day. Good to see you as always. And we're gonna proceed with the white. Are we ready to proceed with the white matter?
Yes, Judge.
Okay, state ready.
Yes, Your Honor.
Court needs to take maybe a 5-minute recess, so we'll be in recess for about 5 minutes.
Thank you, Judge.
Yes. Yeah, fine. Oh, yeah, for sure. Yeah, page. Are you gonna play like the games? I'm trying to figure out. I'm not spending the whole hour now. I'm coming from when, yeah, it's like 27 until after when you finish reading. So every single thing that everyone says, so yeah, I'll just be able to refer to what's in the video. And when people think, okay. Somewhat quickly.
I can't hear anything.
Yes, Your Honor, so we can lay out the case law, but I believe the defense can go first since it's their motion unless they
Okay.
don't want to.
Yes, Judge.
Let me, just for the record again, the court calls the case of the state versus Ariana White, case 21 CR 008025F.
Good afternoon, or yeah, still good morning, Judge.
And Ms. Helen, if you would just identify yourself and your client for the record, please.
Sure, Judge. My name is Patrice Helen. I'm a public defender with Fulton County. This is Miss Ariana White. She is my client today, sitting next to me to my left. Judge, today we have an immunity motion based on OCGA 16-324.2. I am asking this court to grant that immunity motion and allow Ms. White to be immune from prosecution for the current case. Specifically, Judge, I want to lay out some case law that gives the standard that we're going to be using today. It's the preponderance of the evidence. That's going to be Bun v. State. I can give that 284 Georgia Appeals 410-2008. Judge, the right of immunity has the power to stop a trial altogether. It has the power to stop a complete criminal procedure. This is even more powerful than an affirmative defense, Your Honor. An affirmative defense does not have that power. The statute affords my client to be able to have the opportunity to show that her actions rose to the level of OCGA 16-324.2 to be granted for this immunity from prosecution, Judge. The second case that I would like to bring up, Your Honor, is the element that we're looking under OCGA 16-324.2. The element that we are specifically highlighting is justification. Justification under this immunity, Judge. Specifically in State v. Yapo. Yapo is Y-A-P-O. The citation for that case is 296 GA Appeals 158. And Judge, in that case, the trial court properly held that the defendant, who was charged with family violence battery and simple battery under OCGA 16-523.1F, and respectfully 16-523 was immune from prosecution under the statute 16-324.2 because the testimony of the defendant rose to the level of showing justification for those actions. Specifically in Yapo, the testimony of the defendant's friend that the defendant restrained that friend after the friend broke the defendant's windshield and kicked the car, as well as knocking the defendant into the steering wheel. That showed a high enough justification for that defendant to be justified under that immunity, that State v. Yapo, Judge. Also under State versus Bund, trial court did not err by granting the defendant's motion for immunity for prosecution, Judge. Again, there was a proof or justification that met the preponderance of the evidence that those actions were sufficient for that immunity. In this particular case, Judge, I have more case law, but I want to get to the rest of my opening. Ms. White is justified and should be found immune from prosecution because on this date, she is specifically December 30th of 2021, is trying to make entry into her apartment. She is not the only one living there. There is another individual and with her 2 children. The door is locked. This is 1 o'clock in the morning, 1 a.m. when she gets off. As she's trying to make entry into the kitchen window, she makes about 20% entry of her body inside of the window. Her triceps are in, her elbows are in, her wrist is in. And at this point, the alleged accuser in this case comes from the back of the apartment trying to prevent her entry, trying to create some type of illegal eviction at 1 a.m. in the morning towards this location that she lives at, Judge. As he comes from the back window, back room, Judge, she is still 20%. Her elbows are in, her shoulders are in the window, and so is her head. This alleged accuser comes, put his full body weight on this window sill to crush her in the window, preventing her entering to the window, into the apartment, Judge. He actually does this action and then even tells the police on the body worn camera footage that he did successfully prevent her from getting into the apartment. This force was so harmful that it caused blackened bruises from her elbow to her shoulder underneath her tricep, Judge. And so with this evidence, we hope that the court finds that this rose to the level of justification for her trying to get out of the window and biting him in reaction, Judge, to have him release that pressure of the windowsill so that she could get out of the window and get to a safe place, Judge. So we ask that this court grant the immunity motion based on the self-defense because but for her biting him, she'd still be in that windowsill and she would have received much more great bodily injury.
Mr. Stevens, would you identify yourself for the record?
Yes, Your Honor. Jacob Stevens on behalf of the state. Your Honor, this is not a case of self-defense. It's not a case of trying to defend or trying to make entrance into one's own apartment or someone making entrance into property in their possession. This is the case of an abusive, manipulative spouse who continues to terrorize her victim and refuse to leave him alone despite numerous requests and numerous times that the victim has told her she is no longer welcome in his home. There will be a lot of buildup and context for the night of December 30th. That both the defendant's own statements will address, that the victim will testify to. It will go to show the violence that was in their relationship, that prior to December 30th, there had been a contentious past between the two, and that buildup had led Mr. Williams to ask Ms. White to no longer be at his apartment. And when I say it's his apartment, the evidence will show that he was on the lease. He was the one that had the keys. And the reason why he had his separate apartment is because while they were married, she kicked him out. And for 2 months, he then had to be on his own. And then he found an apartment, which then he rented in his own name. And then because of problems that she was experiencing, he allowed her to temporarily stay at his apartment, even though they were no longer together, even though they were no longer, while married, no longer trying to fix the marriage at that point. They were basically separated at that point. And he allowed her to stay there temporarily. Her belongings will not, the evidence to show her belongings of her moving in were not there. They were in a separate location. And again, he had tried multiple times to keep her out. And if Your Honor, may I approach?
Yes. Thank you.
And Your Honor, I've just handed you the case law I'll be citing from. A copy has already been provided to the defense. So first, in terms of the case law for immunity, the defense is requesting immunity based off of, apologize one moment, 16.324.2, specifically A2. And they're talking about a person is justified in threatening or using force against another when and to the extent he or she reasonably believes that such threat or force is necessary to prevent or terminate such other's trespass or the other's torturous or criminal interference with real property other than the habitation of or personal property. Point two, being lawfully in the possession of a member of his immediate family. Your Honor, we will show that this is not her property, and this was not criminal interference with possession of her property. Again, separate apartments. She didn't have keys. She was not on the lease. Even though they were legally married, that is not a justification for why she had authorized entry into the apartment. This has been gone to the Supreme Court and Georgia Court of Appeals multiple times. In State v. Kennedy, there was a husband who burglarized the home of his estranged wife and his mother-in-law. The court held marriage is a significant factor in the determination of whether one spouse is authorized, as provided by OCGA 1617-1, to enter into the separate residence of his or her estranged spouse. However, marriage alone is not an absolute defense to burglary. In all these cases, I'm about to say it's usually criminal trespass or burglary that are involved. There is no express marital exemptions nor implicit exclusions in the burglary statute, which give a spouse unlimited consent as a matter of law to enter the separate residence of his or her estranged spouse. The reason why they go into burglary is because the judge, as you know, 3 elements: home another without authorization, with the intent to commit a felony. They're talking about that authorization. The concurrence, Justice Sears stated, I would like to point out that while 2 people are married is almost easy to define, always easy to define, the point in which a marriage is dissolved and one person no longer has the authority to enter the dwelling of another is often a far murkier. Being separated or estranged can connote many things. It can be seen as a temporary respite, a timeout from a highly stressed marital situation designed to strengthen a marriage. It may be a trial separation or a chance to see what living apart feels like. And I'll skip a little bit to, given the circumstances, we have no choice but to either trust our fact finders to discern when the spouse has truly vacated the hearth and home as a part of the process of dissolving his or her relationship, or to ask our lawmakers or trial judges to create a reasonable bright line rule to the situation. And that was State v. Kennedy in 1996. This State v. Kennedy ruling has continued all the way through 2017. In Williams v. State, 268, Georgia App 384, and 2004. Again, this was a defendant and the victim who were boyfriend and girlfriend. The girlfriend had allowed Williams to move in. He had to pay rent, and he was not supposed to drink. That was a condition that she had imposed. He then broke the conditions, and they broke up. And the defendant had removed most of his belongings, but not all. The defendant no longer had a house key, and on February 25th, Williams broke in and attacked the victim. The court held, once the victim withdraws the defendant's authority to enter the house, the fact that the defendant may have once lived at the victim's house and had left personal property does not in itself give them authorization. Same thing in Bill v. State. The court held, a person commits criminal trespass if he or she enters or remains upon the property of another without the authority and knowledge that has been given notice that his presence is forbidden. And in that one, the 2 parties were divorced but remained amicable, and the victim, the wife, had allowed the husband to stay in a mobile home, but she imposed a condition. He was not allowed to drink. Once he broke that condition, she revoked his authority. Keithley v. State, 305 Georgia App 318, 2010. In this case, they cited the Supreme Court from State v. Kennedy that held, although in the entry of a spouse without consent into the separate residence of the estranged spouse is unauthorized, there is nevertheless no intent to commit a theft, only if they intended to take the unauthorized entry of the belongings of the estranged spouse. So that they've specifically ruled on all the elements of burglary there. That is a separate residence, is without authorization, but the items within you can't do a felony because it's the items that belong to the marriage. But they still held that without authorization still applied from State v. Kennedy. Finally, and I believe this is the most factually on point, Your Honor, in Polanco v. State, 340 Georgia App 292, 2017. This is the last piece that I provided to both state, or the defense and Your Honor. In this case, the defendant, Polanco, had been previously incarcerated for domestic violence against his wife. While in jail, his wife moved all of his possessions to a different house. They then changed the locks to the apartment. And then after Polanco was released and broke into her home once, then there was filed a TPO, and there was a TPO out against the Polanco. The Polanco's name was not on the lease. 2 days later, Polanco then entered the apartment through a bedroom window, harassed his wife, and stopped her from calling 911. Polanco claimed he was only there to get a camera. The court held, again, in Kennedy, there was a holding that there is no express marital exemption nor implicit exclusions in the Berkeley statute which give a spouse unlimited consent as a matter of law to enter into the separate residence of his or her estranged spouse. An entry into a separate residence without authority and with the intent to commit a felony or theft therein constitutes burglary. The jury may consider the fact that Polanco used to live in the residence with his wife, and that the family determining the family in determining whether or not he was authorized to enter the apartment. However, the fact that Polanco may have once lived at the victim's house does not in itself give them the authority to enter. And then specifically, in regards to the bedroom window, they held, moreover, in light of Polanco's forcible entry, the jury could infer that Polanco knew he was without authority to enter his wife's house. Your Honor, all this is going to come to the fact that the defendant did not have authority to enter into this residence. While she had been invited to live there temporarily, it was only supposed to be temporary. There were conditions that were imposed that the victim will testify to. She broke those conditions. She harassed the victim. She harassed her husband. And because of that, he asked her to get out. Therefore, she was not justified to use force to then enter into the apartment. Thank you, Your Honor.
Call your first witness.
Judge, we're going to call Ariana White to the stand.
Raise your right hand. Swear affirm testimony about to give the case to be the truth, the whole truth, and nothing but the truth.
Yes, I do.
You'll have to make sure that you're at a microphone, Ms. Helen.
Thank you, Judge. And for the record, what's your name?
Ariana White,
And how do you know Derek Williams?
my husband.
You're currently married?
We are
Now I'm going to talk about specifically December 30th of 2021. What time did you get home?
about midnight.
Where were you coming from?
Work.
How long had you been at work prior to coming home?
I worked a 12-hour shift.
And what happened when you got home?
I got home. I walked home, walked up the stairs.
I apologize, Judge. Ms. White, speak into that mic as clearly as you
Okay,
can. Yep.
gotcha. I got home. I walked home because I took the train and I walked upstairs. And the door was locked. So I proceeded to open the window.
And what was the address of this apartment that you were staying?
480 Peachtree Hills Avenue.
Who else was living there with you?
My 2 sons, 3 months and like 18 months, and Derek.
And did Mr. Williams invite you to that address?
Yes.
Did he invite you to live at that address?
Yes, he helped me pack up all my things and move in.
When did he invite you to come live at that address?
The specific date that he invited me, I believe, was October 22nd, 2021, because he was
And how did you get into the apartment?
that day.
Correct.
That day, I opened the window to try and get inside.
Which window did you try to open?
The kitchen window.
How did you open the window?
I just opened it and then proceeded to just kind of climb it.
What happened after you opened it?
So after I opened it, it was dark, so I was just trying to get inside, and then within a matter of seconds, I saw him coming around the corner pretty swiftly, and he came in and just immediately closed it.
Who came around the corner?
Derek,
He closed the window.
yes,
Which part of your body was still in the window?
my arms,
Did you scream?
yes.
How long do you think he held you or that windowsill on you?
I would say at least 10 seconds.
Were you able to get out of the window as he's closing it on you?
No, his force was too heavy
How did you know his force was too heavy?
because I tried to get out and I couldn't.
What happened as you tried to get out?
As I was yelling for him to stop, it hurts, stop. And once I saw that me yelling, that didn't do anything, I bit him to try and see if that would get him to stop.
Where did you bite him?
On his arm.
What happened after you bit him?
As soon as I bit him, his grip immediately released. He picked up his phone and said, "I'm going to take a picture of this."
What happened next?
I took that as my moment to get out of the window. I grabbed my phone that had already been inside of the counter so that I wouldn't get locked out without my phone. I grabbed it and I just got out as fast as I could.
Did you call the police?
Yes.
What happened when you called the police?
I called the police and I told them what happened. This is probably like the third or fourth day I had been locked out. And I told them the same thing I told them.
Has he locked you out before this December 30th, 2021 incident?
Yes.
What happens when the police arrive?
When they arrived, there was a female cop and she saw me. She came and she asked me what happened. I told her what happened and she called for male cop backup.
Did you tell them that Derek closed you in the window?
Yes,
Did you tell him you had bruises on your arm?
I did. Yes.
Did they take pictures?
No.
Did you take pictures?
Yes. But not that day. So I told the female cop, I told her what happened. I told her that, I bit him. Once they went to go talk to him, he told them as well that I bit him. He decided to press charges and I was arrested. I did tell them I had bruises, but they did not ask to see. And I did not take pictures until after I was released from jail.
When were you released from jail?
I was released from jail January 1st, 2022.
When did you take those pictures?
I took those pictures because I didn't have my phone. I had to go to the public safety annex, but it was a holiday, so I had to wait. And once I got my phone, I went home and took pictures on January 3rd at 2 p.m.
How did you know that that was January 3rd at 2 p.m. that you took those pictures?
Because the iPhone has timestamp dates on them.
Do you still have those photos?
Yes.
Did you ever go to the hospital for those bruises?
No.
I'd like to talk about as you're in the window. What happens as you're in the windowsill?
As I'm in the windowsill, can you explain?
Sure. When you enter the window, how much of your body is in it?
About this upper part.
So your tummy is,
I would say the breast area.
so,
Yeah.
so the window is hitting your chest as you're leaning in?
No, so my arms, and I guess you could say my chest partially, but mainly my arms.
Okay. Judge, that's all the questions I have.
Cross. Yes, Your Honor, one moment. Your Honor, the Zoom link, is it the same one we usually use? Yes. I'm one moment while I join the Zoom link, Your Honor.
Okay.
Mr. Stevens, are you attempting to share an exhibit?
I will be.
Okay.
And Your Honor, is it okay if I remain sitting for cross-examination?
fine.
Ms. White,
Yes.
you said Mr. Williams had invited you to stay at that apartment
Yes.
and that he had helped you pack up all your things.
Yes.
When you say all your things, what are those?
Well, I was living with my mom, so it was my dresser, my bed, all of my, really just literally every single thing that, all of my clothes, kids' clothes, toothbrush, books, wigs, everything that I owned.
And not all of those things were in the apartment, were they?
They were.
There was nothing in a storage locker separately?
Oh, actually, there was a couple of things in storage. The big things that didn't, because it was a small apartment, so the big things were in storage, but just the things that I needed. Sorry. The things that I needed on a daily basis I had, but the major things were in storage.
So only basic necessities were inside his apartment.
There were other things that weren't really necessary necessities, but I would say about 80% of my belongings were in the apartment.
And you stated that your arms were in the window?
Yes, sir.
And was that the only part of your body that was in the window?
Really just the upper half. So
can you demonstrate when you say in the window, what exactly you mean? Where the window would be and what part of your body was through it, in it?
So, as you know, they have the window sill that has that sharp part on the bottom of it. And so as I was climbing in, that's the part that was in the window.
I'm sorry, can you demonstrate?
Yes, like this.
So am I to understand the podium being the front or the back? So is you're saying that your torso was through the window?
I would say like not my torso, not the lower part, just this upper part.
And that was through the window, not at the window?
It was in the window, yes, through the window.
So your head, your upper torso area and your arms were through the window. Isn't it true you told the officer it was only your fingers and your arms?
No, I don't remember that. I remember telling them, I remember telling my arms were in the window, but I don't remember saying only my arms were in the window.
You didn't tell the officers that your head was through the window?
I don't know if they asked or not. I just kind of told them because that was the part that got damaged. So that was the part that I emphasized to them.
Ms. White, my question was, you didn't tell the officers that your head was through the window?
I don't remember.
Would seeing a couple of your statements refresh your recollection? Your Honor, since there's no jury, is there any objection to playing the audio to refresh your recollection, or would you like to step out to watch the video in terms of refreshing recollection?
Which audio are we talking about?
The body worn camera of her own statements.
You do here. Yeah, you don't miss.
And just for the court's edification, is there some relevance as to what was or was not through the window?
Yes, Your Honor. And not only does it go to what was through the window was not, but also goes to the credibility of her statements and the conflicting statements she's made. I know this is for. I know this is for the purpose of refreshing recollection, but for the record, I'm playing the video at 12 minutes and 55 seconds.
Share your sound.
Okay, like I shouldn't have bit him, but it's like when my hands and my fingers are in the window and you're literally like he's stronger than me, you know, like I don't have.
Apologize, there's some.
Yeah, screen.
To do at this point, like he has my kids up there, like he's holding my kid and he's looking at me through the window. 3 months and 18. And okay, like I shouldn't have bit him, but it's like when my hands and my fingers are in the window and you're literally like he's stronger than me, you know, like I don't have another choice, and I just don't know what to do at this point. Like,
Does that help refresh your recollection?
I do remember that night.
So you did not tell the officers that you're. On the night of December 30th, you did not tell the officers that your head and torso were through the window.
They didn't ask me.
Ms. White, my question was, on the night of December 30th, you did not tell the officers that your head or torso were through the window, right?
I didn't. I didn't really emphasize that. No.
Ms. White, again, I have to ask,
Objection, Honor, asked and answered.
Your Honor, she's not answering the question. She's saying I didn't emphasize something. That's not the question. Did she or did she not tell the officers that her head and torso were through the window?
I did tell them I was in the window.
And
Question is, did you tell them that your head? Say the question again and give me a yes or no answer.
Yes,
What's
Your
the
Honor.
question?
Ms. White, on the night of December 30th, you did not tell the officers that your head and torso were through the window.
Yes, I don't know what you're trying to.
Yes, you did not tell them.
I think the question's confusing. You did not tell. Did you tell the officers that your head and torso were through the window? Is that your question?
Yes, Your Honor.
Okay.
Yes.
I'll move on, Your Honor. You testified on direct that you bit him in order to get him to stop,
Yes.
but you've previously told officers that you bit him in order to get him to move.
Can you explain that question?
On the December 30th, you told officers that you bit Mr. Williams to get him to move.
To move from closing the window.
And you told them, you testified on the direct that you told them that you had bruises.
Yeah. Yes.
You never showed them those bruises.
No, they never asked to see them.
Ms. White,
Yes.
did you ever show them any bruises?
No, I did not.
You testified you took those pictures on January 3rd,
Yes.
which is 4 days after the incident.
Yes.
Ms. White, I want to go to the actual apartment itself. You were not
Excuse
on the
me.
lease.
Does he need to still share his screen? If not,
I apologize. Thank you.
thank you.
Sorry about that.
Mhm.
Ms. White, you were not on the lease.
No,
You did not help pay for the rent.
no, because the agreement was that I was saving up to get my own place.
And Mr. Williams had invited you to live in the apartment
Yes,
after you had kicked him out of your home,
my mom's house.
but you had kicked him out.
Yes,
And he invited you to stay there because of issues you had with your mom.
yes,
And on the night of December 30th, you didn't have keys to the apartment.
no,
And the door was locked when you tried to get in.
yes,
And you decided to then instead go through a window
yes,
that you had done previously as well.
yes,
When you were entering the window, you said that Mr. Williams tried to shut it on top of you.
he didn't try, he did.
Thank you. And you said that you got bruises on your arms.
Yes,
And I don't believe that it was actually tendered in evidence, but Your Honor, may I approach?
Yes.
Ms. White,
yes,
are these the bruises that you testified to?
yes,
Is this picture a fair and accurate description of the bruises you were talking about?
yes,
Has it looked like it been altered or any sort of alterations made to the photo?
no,
So it's a fair and accurate copy of the photo that you provided for the motion.
yes.
Your Honor, at this time, I'd like to tender, if the defense hasn't already, what was pre-marked as Exhibit A and C.
Any objection?
No objection, Judge.
Admitted without objection.
Your Honor, I give you C or A.
A.
In regards to the window, Ms. White, were there any barbs or metal spikes on the window?
The bottom part was sharp,
They're sharp. What do you mean by sharp?
just sharp, you know how like that window, the bottom part is, it's very thin, and sharp.
Sharp like it would cut you?
Not I mean, it could, that is a possibility, but definitely sharp to the point when having pressure, it would definitely cause marks and bruises.
And these, I believe I took the photos away. Those bruises, they show your bruises on the underside of your arm
Yes.
and they show the top of your arm, correct?
Um,
I can show you the exhibits if you need them again.
I can see the exhibit again, but I believe it's,
In the photos, and I'll wait for you to get that, sorry. In the photos, you can see the tops of your arms.
that looks, no, that's the bottom. That's the bottom of my arm, my triceps.
In exhibit A, on that bottom left-hand side, can you
Mhm.
see the top of your right arm?
No.
In exhibit C, in the bottom left-hand side, can you see the top of your left arm?
It's actually the same arm. It's when you take a photo with the iPhone in the front camera and the back camera, it just looks flipped, but it's actually the same arm.
So there's only bruises on one arm?
There was actually bruises on both my arms.
Can you see from the photos the top of both of your arms?
No,
You have not submitted any photos of bruises to your back?
no, my back wasn't in the window, just my arms.
It was just your arms in the window?
It wasn't just my arms, but it was my it was my back wasn't in the window. My back wasn't affected at all.
Ms. Williams, you and Mr. Williams have, sorry, Ms. White, I apologize.
Thank you.
You and Mr. Williams have had some issues in your marriage,
Yes.
and those issues have sometimes been violent,
Yes,
and you've admitted to doing violence to him.
not intentionally.
My question was, you have admitted to doing violence to Mr. Williams,
Yes.
and you've admitted that all he ever tried to do was peace and reconciliation.
That was not the truth, although that is what I said.
So you said all he wanted was peace and reconciliation.
Yes,
And you said that he has been brave, enduring, kind, and patient with you.
that wasn't the truth, but that is what I said.
And you've said that you weren't able to control your emotions and you let your emotions lead to anger and violence.
Mhm.
You have to answer verbally. Yes. or
Oh,
no.
yes, sorry.
Your Honor, at this time, I have no further questions.
Just a redirect, Judge. Since that video, I don't know if that video is still up. I have it on mine, but could I play 12:39?
You do whatever
Yeah.
you'd like to do, Ms. Howard.
For the Zoom conference. Okay, great. I just shared my screen. Oh,
Ms. Helen, are you attempting to share your screen?
yeah.
All right, Mr. Stevens, I'm gonna take the co-host away from you and give it to Ms. Helen.
Understood.
Still disabled. Just go ahead. Okay. Need to mute your computer. I'm muted, but how do I hear the audio from mine? Do you unmute it?
You just
Share sound, okay. Share sound. Yeah, okay.
And Your Honor, before we play the video, I would just object in terms of laying whatever foundation or whatever the purpose is for
Sure.
this video.
Judge, Ms. White, for redirect, you did tell the people, or the police when they arrived that Mr. Williams slammed the window on your arms. You did motion to the area of where he slammed. That area is,
Your Honor, this point she's testifying, she's not asking a question.
was that area underneath your arm?
That's my tricep.
Was that the area you informed police that you had received bruises?
Yes,
And you did tell the police you did receive those bruises
yes,
from being slammed in the window?
yes,
That night that you spoke to police, was that December 30th of 2021?
yes,
Was that a female officer that you spoke that to?
yes, and the male officer.
And can I play the moment where she tells the officers, or at least the female officer?
There any objection?
Any
Yeah.
objection? Thank you.
I didn't know that he was home, and so I had to got the window open, and he came around the corner and started closing the window, like it was in my arms and hands are.
She says it right there, the officer walks away, she tells the
Your Honor,
officer.
objection, she cannot testify to what is
Well,
being
Ms.
said in
White,
the
did you
video.
tell the officer, even though she walked away, that he slammed the window on your arms?
Yes,
Was that area that he slammed, that you received the bruises underneath your arm?
yes,
And was that in this interaction with this window just moments before this officer arrived?
yes.
And did you call the police?
Yes, I did.
No further questions, Judge.
No recross, Your Honor.
Okay, I have some questions, because I don't understand, why you all are focusing on the arms, the head, in the window, not in the window. If it were me and I get home and I'm not, and my door is locked, first thing I'm gonna do is ring the doorbell. Did you ring the doorbell?
I did knock on the door.
Okay. Nobody came to the door. Your next thought was to go into a window?
It's because the night before, he had locked me out. That's how I got in. And I called, that night, the night before, I called the cops, to tell them, you know, he's trying to evict me, and they would always say the same thing. You know, you're legally married, you've been living here for more than 3 days. If he wants to evict you, they just kind of say the same thing. So because I had gotten through the window the night before, that's why I tried to do it that second night.
Okay, this is a kind of question that's helpful for the court, okay? Knowing what the circumstances are, knowing, you know, what the background is for both of you on this evening. So you knew that you weren't, that you might not be able to get into the house that night,
Mhm.
yes?
Yes,
And you knew that because of the previous night.
yes.
And did he not want you in the house?
He was trying to kick me out, yes.
Okay, so you all had some conflict before this time.
Yes.
Okay. Did you know he was home?
No, I did not.
When did you think your children were?
Well, he didn't tell me. He never would. But that the night before that I climbed in through the window, I didn't know where they were. So that night I didn't know either because he wouldn't. I just
What
didn't.
time did you get home?
Midnight, 1 o'clock.
Where did you expect your children were gonna be?
To be honest, I don't know, Your Honor. I don't. He would just take them to go sleep at someone else's house, and I wouldn't know.
Okay. And I don't, and again, as far as the in the window, outside the window, you all need to present to me. I don't, you know, did she bite him while he was in the window? I mean, how could you bite somebody if your head was not in the window and just your arms were? That doesn't make any sense to me.
Mhm.
So you all want to flesh this out a bit for the court so that I don't have to keep doing this?
Sure.
Your Honor, I can continue questioning, but that was going to be part of my main argument, that she keeps making inconsistent statements about what her.
Well, you
answer
have
is
this
not.
witness on the stand. You can ask her anything that you want to ask her to make sure that the court understands what the situation is and why I should rule in your favor. So that's what I need for you to do, because right now it's all, it's all very sketchy for, for the court as far as what your argument is. And she's here. She can answer all of your questions to make it helpful for the court. I don't want to have to keep questioning her.
Yes, Your Honor. I can continue questioning. Also, I was going to have our witness to testify to those facts, but I can continue, Your Honor, if you would like.
Well, if you have any other questions for her,
Would you like for defense to go first or the state, Your Honor?
if anybody has a question before I release her, if you don't have any questions, then, that's fine with me. But, how often do you get a defendant on the stand?
Ms. White. You were coming home from work? Or did you come home?
Yes.
Where were you coming from?
From work.
Why did you go through the window?
Because that was the only other option that,
Speak as loud as you can to that mic.
because that's how I had proceeded to get in the night before.
Did you feel that you lived there, that you were residing there?
Yes.
Had he filed any official eviction notice against you?
No.
When the police arrived, the police stated that he can't just put you out,
Yes.
and that he told police that he tried to put you out other times,
Yes.
and that on this time you came through the window,
Yes.
and that the previous time you weren't able to get in.
Can you explain that?
The previous times he tried to lock you out from the apartment. How did you get in?
I would just wait it outside. So yeah, I would just wait outside. One day I was locked out. I waited till he got there. And then the second night, he wasn't home. The kids weren't home. I climbed it through the window. The third night, I climbed it through the window, but this situation happened.
And would your kids sometimes be sleeping or staying elsewhere?
There was only one other time, which was that night that I climbed it through the window and they weren't there.
Were they there later on when the police arrived?
No, they never came back until the very, till the next day.
How long were you at that window before you tried to climb in?
Um, Not long, because to me, it was just, I did it the day before, so to me, it was just go in, go to sleep, get in through the window and go to sleep.
Was there a back door you could have gone through?
No,
Why did you choose the window?
because it was the way I had gotten the night before, and because the door, he wasn't answering the door.
But did you knock on the door?
Yes,
But you didn't ring the bell,
there was no doorbell to be rang.
but you knocked on the door
Yes,
and no one came?
no,
And it was about midnight.
yes, midnight, 1 o'clock.
Was there any pressure when you were trying to open the door? I mean, open the window?
What do you mean pressure? Like someone?
Was it easily openable?
Yes,
At what point did you see Derek in the apartment?
as when I was in the window, that's when I saw him coming.
How did you see him?
Because he walked up to me.
Did you make eye contact?
Yes.
Did you guys talk?
No.
How much time did it take him to meet you at this window?
Milliseconds.
Where is your arms in relation to the windowsill? Are your arms outstretched or are they bent?
They were bent.
Why were they bent?
Because, oh, I'm sorry. Because I was actively trying to get in.
Say it again, Ms. Wade.
They were bent because I was actively trying to get in.
Get in where?
Through the window into the apartment.
How tall is this window?
Oh, it wasn't very tall. It was about my height.
So the window's eye level.
Definitely eye level.
Did you need to hop to get in it?
I mean, sit on my tippy toes, yeah, but not so much like jump, no.
So you opened the window and you kind of got on your tippy toes to enter the window.
And set my phone down.
Where did you set your phone down?
Right there on the counter on the right.
There's a what on the right?
A counter on the right.
There's a counter on the right and you saw this counter? So you put your phone down and then you make more entry into the window?
Yes, I put my phone down and then I made more entry, and that's when he came to close me in it.
Are you leaning in the window?
Yes.
Are you leaning in the window because you're on your tippy toes?
Yes.
Okay. And your head is inside the window?
Yes.
And he closes the window?
Yes.
He closes the window onto your arms?
Yes.
At any point, does it hit you in the head?
No, because there was also, it was kind of propped open, but not that I remember, I mean, it's possible, I don't remember. I just remember the main damage was to my arms.
At what point did you try to get out of the window?
As soon as he closed it and it hurt, I tried to get out.
How long is this struggle of you and Derek in this window?
It was at least 10 to 30 plus seconds, definitely 10, 15 seconds, because I was yelling to get him to stop, assuming that he would stop and I would be able to get out. And once I saw that me yelling didn't do anything, that's when I proceeded to bite him, and that's when he stopped.
You talked about the windowsill. Is it spiky?
It was sharp, not spiky, but thin and sharp.
Sharp enough to cause a bruise?
Yes.
Was it sharp enough to cut your skin?
Possibly, yes.
Did you have long sleeves on?
Yes.
Did it cut you? Did the windowsill cut you through that long sleeve shirt?
It didn't cut me, no, just.
Did it bruise you through that long sleeve shirt?
Yes.
No other questions, Judge?
Anything else? Yes, Your Honor. Ms. White, you filed a TPO after this incident,
Yes.
and when you filed that TPO, you described what happened on this night.
I described a lot of events, but yes.
Would you recognize a copy of that TPO?
Yes.
Your Honor, showing the, I'm sorry, may I approach?
Yes.
Your Honor, showing the defense counsel has already been provided in discovery.
Thank you.
Ms. White, what is this?
This is a copy of the TPO.
And is it the same TPO you filed?
Yes,
Is it a fair and accurate copy of the TPO you filed?
I believe so.
Your Honor, at this time, the state would like to tender into evidence a copy of the TPO marked as State's Exhibit 1.
No objection, Judge.
Admitted without objection.
Ms. White, please turn to the second page
Yes,
and please find the sentence that says December 29th.
yes.
Please read from that that paragraph until I tell you to stop.
Derek forced the kitchen window shut on my arms, and as much as I yelled for him to stop because he was hurting me, he is stronger than me and continued to shut my arms in the window.
Thank you.
I had,
So in the TPO, you only mentioned your arms.
because that's where the damage was.
In the TPO, you only mentioned your arms.
Yes,
Going to how you got through the window. You said you put your phone through the window, that your arm was fully inside the apartment and crossed the threshold.
Mhm.
And then you also mentioned that you were on your tippy toes and at least your breast area was through the threshold.
yes,
And at the time that he's closing the window, he's closing it while your breast is through the threshold.
partially.
Define partially.
I don't know, just like right here,
What part of your body is through the window when he is trying to close it?
this part and above.
So that part and above, and to be clear, you're referencing your breast and above, is through the threshold of the window. You have not submitted any photos of bruises on your neck.
No, but I didn't receive any bruises on my neck.
You didn't put any photos of bruises on your shoulders.
The window didn't touch my shoulders, just my arms.
Are your arms extended through the window?
They were bent.
So somehow your breast and above is through the window and your
Yes,
arms are
yes.
behind you.
Yes, like that.
You didn't
yes.
submit any photos of bruises on your hands.
I didn't have any bruises on my hands.
When Mr. Williams is closing the window, he's trying to close it from above.
Yes, I guess.
His arms are pushing down the window.
To be honest, I don't remember exactly the positioning. All I know is that the way that it was kind of like this, because this part of this arm was showing, and that's why I bit him.
So you bit his arm
Yes,
as he was closing it on you.
yes.
You didn't pull his arm out the window and bite it.
No.
Your Honor, may I approach? Showing the defense counsel. Ms. White, do you recognize that?
Yes,
What is that?
that's the window that I entered. Tried.
How
to
do you know
enter.
that that's a window that you tried to enter through?
Because it looks similar.
So is that a fair and accurate copy of the window you tried to enter?
I believe so.
Your Honor, at this time, I'd like to tender into evidence State's Exhibit 2.
Any objection?
No, Judge.
So that's the sharp window that you tried to enter through.
Yes.
Your Honor, at this time, no further questions.
Nothing further. Thank you, ma'am.
Thank you, Judge.
Call your next witness.
That's all the witnesses I have for the defense, Judge.
Stevens.
Your Honor, at this time, the state would call Mr. Derek Williams.
Yes, sir. Derek Williams, Jr.
Mr. Williams, what do you do for a living?
I'm a client's implementation consultant with electronic health records.
And where do you currently live?
Houston, Texas,
And how long have you lived there?
for about a year now.
Prior to living in Texas, where did you live?
Atlanta, Georgia.
Did you live at 480 Peachtree?
Yes, sir.
And Mr. Williams, how many children do you have?
I have two boys.
And are those two boys yours and Miss White's?
Yes.
Ms. Williams, I want to ask you about your relationship with this Miss White. Who is Ariana White to you? Oh, sorry, Ariana White.
She's my wife and kid's mother.
And how long were y'all in a relationship for?
2 years, 2.5 years.
How would you describe your relationship over those years?
Abusive, chaotic, tough.
Abusive on whose part?
Abusive from her.
Anytime were you abusive to Miss White?
No, sir.
At what point in your relationship did you and Miss White begin separating?
May of 2021.
And what was that separation exactly?
I slept in the bonus room of her mom's house.
And was she in that room with you?
No, sir. She kicked me out of our bedroom.
And what were some of the reasons for that separation?
I was getting tired of apologizing again and again for her reacting to petty situations and making it an extreme argument and making it public.
And at some point, did you stop living in the same house as Miss White?
Yes.
For how long were you physically separated at that point after you moved out? So you were kicked out.
About 4 or 5 months.
And what did you do during that time?
I had just started a new job as a clinical support specialist, so I was in training.
Where were you living during that time?
Atlanta, Georgia.
Were you living with a friend? Did you get your own place? What were you doing after you got kicked out?
After we got kicked out, I didn't get a place yet. Someone had offered that I could stay with them.
And approximately when did you get the address at 480?
It was the end of September.
And what month were you kicked out?
August.
August. So approximately almost 2 months you were living at a friend's.
Yes, sir.
And when you got the apartment at 480, did you get that apartment with Miss White?
No, sir.
Was her name on the apartment lease?
No, sir.
Why not?
I didn't want to live with her.
I'm going to talk about that time from early August until the end of September. Were there any issues that happened?
Objection, Judge, relevancy.
I'm gonna let him.
Just responding to the objection, it goes to why she skipped out. Were there any issues during that time between August and September between you and Miss White?
Yes, a
Can you
lot.
describe some of those issues?
Shortly after she kicked me out, she hacked my bank accounts, my Chase, my Cash App, my Gmail, and my IRS.gov account.
And what did she do after she hacked those accounts?
She withdrew money.
Objection, Your Honor, relevancy.
I'm gonna allow it. Go ahead.
She withdrew money from my accounts.
And with your permission?
No, sir.
Were there any other issues that occurred during that time?
There was another incident whenever I tried to pick up my son, which was a routine thing. And she stopped me from picking him up because I didn't provide her with the basket that she gave me when she kicked me out.
Can you go into a little more detail about what happened during that incident?
I had just got off of work and I had texted her to let her know that I was on the way. And she responded by saying, if you don't have my basket, then you can't come over. I said, well, I'm on the way already and I don't want to make an extra trip. So I get there and I knock on the door. She cracks it open and then I try to squeeze through the crack. she opens the door wider, and my son was right there, so I picked him up, and I tried to go upstairs to get his car seat. He had two. And so I tried to go upstairs to get the car seat, and she, 9 months pregnant, blocked me from going upstairs. And so I tried to go around through the garage, and she chased me in her mom's house. I went to the garage. She didn't follow me to the garage, but whenever I opened up the garage door, she was outside of the garage door by my car. And so she proceeded to take the items from my hand. I had his diaper bag, I had his car seat, and she just took everything from me.
And was this all in front of your son at the time?
Yes, it always was in front of our son.
After those issues and after you moved into your own apartment, at what point did Miss White come to live with you?
It was the weekend of Halloween.
And why did she come to live with you?
She said that her mom was threatening to report her, and that she was secretly recording her, and they were just arguing, and she was going to put her out.
Report her for what?
For letting the baby cry and leaving him unattended.
And why did you invite her to stay with you even after she had kicked you out?
I had sympathy for her, regardless of what was going on. I was raised by a single mom. I didn't want to put her through a situation where she just didn't have anything. The kids were struggling because she was struggling. So since someone gave me a random opportunity, I figured the mother of my kids, I can do the same.
And how long was she supposed to be staying with you for?
2 months.
And what were the dates of those 2 months?
I think it was Halloween the 31st through December 31st.
And what was supposed to happen at the end of those 2 months?
She was supposed to have, been stable, have a place, have a job, have her own source of transportation.
Were any of her belongings brought over to your place?
A few.
When you say a few, can you describe what was brought and was not brought?
She had this pregnancy pillow that I got her. She had some books, a journal, clothes, and blankets.
And was the majority of her items in the storage locker?
Yes.
Were there any conditions that you asked Ms. White to do in exchange for her staying with you?
Yes. I made it clear to her that I did not want to be with her, and that if she was going to live with me, then she just had to focus on herself and helping me take care of the boys, because she worked from home. I wanted to put the boys in daycare. She didn't want to do that. So I just asked her take care of the light bill, the cable, and take care of the boys.
And did she follow those conditions?
No.
What happened? How did she not follow them?
She just didn't do it. And whenever I brought it to her attention, it just became an argument.
I apologize. Can you be more detailed when you say, for example, the bill? Was she helping pay with the utility or the electronic bill?
No, sir.
And when you say watching over the boys, how was she not watching over the boys?
Because there would be certain times where I was either on call or just going out. And as soon as I get there, my downstairs neighbor would come to me and tell me that the boys have been up since 12 o'clock, 1 o'clock. And then I make it into the apartment. All the lights are on. It's past midnight. The boys are awake. She's trying to feed them at midnight. It was just, and the neighbor even told me, and Ariana herself told me that the neighbor had been hitting the ceiling during the day.
And were there times where you weren't able to go to work?
Yes, sir. We had an on-call schedule, so it would alternate. And we also had it in advance. So I would let her know I have to be on call for this weekend. And so this one weekend, I had just finished getting ready and I walked out to the apartment and she wasn't there. So I'm calling her, she didn't respond. And then she texted me and told me that she was at work. So I couldn't go, I couldn't be on call that weekend. And the following incident, a coworker watched the boys for me.
At what point did you ask Miss Aria or Miss White to move out?
Like what day or what incident?
Both, I guess.
I just know it was arranged like just after Thanksgiving. And it was because talking to her went from us co-parenting to her just repeating, like going back to how it was when we were living with our mom, where it was just argumentative, deflect. She would just deflect and then just insult me.
And going to the actual day, do you know at what point you asked her to move out, to get out of the apartment?
I don't remember.
Do you have a general time of, was it like a week before, a couple of days before December 30th, or not sure?
I would say like maybe a week or two before.
And what steps had you taken in order to get Miss White out of the apartment?
I called her dad and asked if she could stay with him. I reached out to one of her friends and asked I think her name was Kyra, something like that. I asked her if Ariana can live with her.
And what actions did you take to stop her from being able to enter the apartment prior to December 30th?
Could you say that again?
What actions did you take to stop Miss White from entering prior to December 30th?
I changed the locks.
Now I want to go to the actual incident, December 30th. Prior to December 3rd, the night of December 30th, had you told Miss White multiple times she was no longer allowed to be there?
Yes.
And from your point of view on December 30th, what happened?
I'm sorry, say that again.
On the early hours of December 30th, from your point of view, what happened?
So I was in my room asleep with the boys and it was lightning and thunder. So, but I kept hearing like a rattling noise. I never heard a knock at the door. So I kept hearing like this rattling noise. So I got up to check it out and see what was going on. And I had my flashlight on my phone. And so I looked in the kitchen and that's whenever I saw the window was open. And I just ran to the window. I didn't know it was her yet. I just saw the window open and I just ran to the window. And whenever I get there, she pops up and she's trying to stop me from closing the window. And so she propped her arms up just like this with her hands up open. And so while she's like that, I was closing it. And so I was closing it. She didn't move. And so with my right hand, I grabbed her arm and I pushed it out. And after I did that, she bit me.
So your arm was outside the window when she bit it.
Yes.
And did you tell Miss White to exit the apartment or exit the window?
I didn't say anything to her during that exchange, I didn't say anything to her. Afterwards, she said that she was going to call the police. And I said, that's okay. You've given me everything I needed.
And now I want to go to a family violence protective order. Did you file a family violence protective order after this incident?
I tried to, but I don't think I followed their steps correctly. The family division, they did email me the paperwork, but I emailed it back. I didn't e-file it. I didn't know to e-file it.
Did you give an answer to Ms. White's petition for a TPO?
I did.
Would you recognize a copy of that if it was provided to you?
Yes, sir.
May I approach, Your Honor? Mr. Williams, what is that?
This was my response to the TPO.
How do you know that that's your response?
It's my handwriting in my response to the lies that I saw that were on the TPO.
Is that a fair and accurate copy of your response?
Yes, sir.
Your Honor, at this time, we would like to tender in the defense response to the TPO as State's Exhibit 3.
The objection?
Did the judge issue a ruling as to your and Mrs. White's TPO?
Yes, she dismissed Ariana's and granted my answer and counterclaim.
Would you recognize a copy of that dismissal order if it was provided to you?
I would.
Permission to approach?
Yes.
Joint Defense Counsel, what has already been handed over in discovery? Mr. Williams, do you recognize that?
I do.
What is that?
This was, I don't know, like this was the order that the judge sent out.
And how do you know that that's the order?
I recognize the time frame 1/24/2020 to 1/23/23.
And is that a fair and accurate copy of the order?
Yes.
Your Honor, at this time, I'd like to send her into evidence the family violence order issued as State's Exhibit 4.
Objection, Judge.
Made it without objection.
Bailiff, would you mind handling those to the judge? And Mr. Williams, you already said it, but for clarity, what was the date for that TPO, the family violence order?
Believe it was January 22nd, 22 through the 23rd of January 23.
And this was approximately 22 days after the incident that we've been discussing?
Yes.
Mr. Williams, when she was, before she bit you, did she physically grab your arm?
No.
Okay. And
if I may add, she was not screaming or yelling for help either.
And when you were trying to close the window, was it because you were trying to prevent her from entering the apartment you had told her no longer to go into?
Yes, sir.
And did you plan to do any physical harm to Miss White at all?
Never.
Were you trying to harm her that night?
No, sir.
Mr. Williams, did Miss White ever apologize to you for the violence that she had done to you?
A lot of times, yes.
Was there ever any form of a letter?
Yes.
Would you recognize that letter if it was placed before you?
Yes, sir.
Permission to approach?
Yes.
Counsel, I have it handed over. Mr. Williams, what is that?
This is her apology letter that she gave me when I went to go pick up the boys.
How do you know that that's the apology letter she gave you?
Whenever I had made it to her room at her mom's house, she said, I have something for you. And it was 11 pages folded together in an envelope. And I tried to read it right there, but she told me not to.
I'm sorry, for clarity, how do you know that is the letter that she gave you?
Oh, I recognize her handwriting and I can't forget some of the stuff that she mentioned.
And is that a fair and accurate copy of the letter she gave you?
Yes.
Have there been any material alterations to that?
No.
At this time, the state would like to tender into evidence State's Exhibit 5.
I'd like to object, Your Honor. I don't know when this letter was written. Ms. White did say she wrote it, but I just don't know the date or time or for the relevancy of December 30th of 2021. I do hear the TPO, August, September, October. I just don't know when that letter was written. Neither does Ms. White. And so
Your Honor,
I think it's irrelevant, Judge.
Okay, I can clarify the time frame that it was written, Your Honor. Mr. White, to your knowledge, when did you get that letter?
It was after Era was born, our youngest son.
Was that before or after you were kicked out of your home?
After I was kicked out.
And was this before or after the incident on December 30th?
Before.
And then, Your Honor, going to the objection for relevancy, This goes to the nature of the relationship, prior difficulties they had, and goes into why Mr. Williams did not want the defendant in the home, because as he said, she was going back to how she used to be. So that's the relevancy portion of the letter. And it's the defendant's own statements.
Taylor,
No objection, Judge.
admit it without objection.
Mr. Williams, on page 1, do you see that highlight portion?
Yes.
Can you read that highlighted portion?
I'm so sorry for being emotionally, verbally, and physically abusive to you and ruining every promise I ever made to you. You were nothing but good to me, and I kept hurting you.
Can you go to page 5? And can you read the highlighted portion there?
I'm sorry for not knowing how to resolve conflict and how to communicate. I'm sorry for who I became at my worst moments, for choosing violence and anger and rage when I could have chosen peace and reconciliation, because that's all you ever wanted.
And then can you go to page 8? And could you read the highlight portion?
I am reminded of how courageous, bold, brave, enduring, and patient you are and have been.
And finally, can you go to page 11? And Mr. Williams, whose name is on the bottom of that?
Ariana.
Finally, Mr. Williams, going back to the bite, can you try and demonstrate as best as you're able exactly how the bite occurred? Not just saying verbally, but demonstrate.
Yes, sir. So like I said, her hands were like this in the window. And we were right there for a while. So I grabbed her, I guess her left arm, and I moved it out of the window. And whenever I was moving it out, she pulled it out and she bit me and she held down. It wasn't just like a quick bite to let go or anything like that. I was actually trying to get her out of the window. It wasn't as if she needed to cry or scream for help. I was trying to give her that way out.
And did you tell officers that night about the bite?
I did.
What did they do as a result?
They asked me if I wanted to press charges, and I said yes.
No further questions, Your Honor.
Press?
Bailiff, actually, I was going to grab my copy. I apologize.
Good afternoon, Mr. Williams.
Hello.
How do you know Miss Ariana White?
We're married and we have kids together.
And I'm specifically going to talk about December 30th, 2021, okay?
Okay.
You testified you were at home?
Yes.
What address, or this address was the 480?
480 Peachtree Hills Avenue.
And you testified she's not on the lease, or she was on the lease?
She was never on the lease.
You did also testify that you invited her to live with you at that apartment?
Yes.
You also testified that it was some requirements that she was supposed to keep in exchange for that residency?
Yes.
One of those requirements was a job.
Yes.
She did complete that requirement.
For a little while. She quit that job.
She did complete that requirement of having a job. Correct?
Yes or no? She quit that job.
Did she initially get hired with the job?
Yes.
How long did she keep that job?
For like a few weeks, like maybe 3-4 weeks.
On December 30th, 2021, you testified that Miss White texted you she was at work.
Say that again?
You testified that you were texting Miss White, she wasn't answering, correct?
That did not happen.
December 30th, 2021, did you testify that you tried to contact Miss White to see where she was?
No.
Did you
I knew
make
where she was because December 29th, whenever I made it to the apartment, she was there and I didn't know how she got in the apartment. So I knew where she was going.
Did you testify that you knew where she was December 30th?
I knew where she was.
Where was she?
at work.
And the job that you testified she only kept for about 3 to 4 weeks?
That wasn't the same job. She had 2 jobs,
So she did get 2 jobs,
not at the same time.
but she did get 2 jobs.
Okay,
Yes or no, Mr. Williams? She did get 2 jobs.
she had to.
Uh, I'll move on. So one of the other requirements is for Mr. Or Ms. White to be an excellent caregiver to the 2 boys, correct?
Correct.
During this care, she was supposed to be watching them
Yes,
and feeding them.
yes.
Did she watch them?
She watched them.
Did she ever feed them?
Sometimes,
Did she clothe them?
sometimes.
Was there playtime?
I wasn't there.
Where were you?
Work,
Did she take them out?
no. She didn't have transportation.
Also, you testified that one of the requirements to live at the 480 apartment was to essentially not pay utilities.
Not pay, I'm sorry?
You never asked Ms. White to pay utilities.
I did.
You stated that the main conditions for her to reside there was childcare.
Childcare and utilities.
Utilities for the 480?
For 480, yeah. She was working from home. Her first job, she was working from home. And so I told her she didn't have to help me with the rent, but she could take care of the electricity and internet.
So she was
They were the
taking,
cheapest.
she was taking care of utilities at a place she didn't live?
That was the agreement.
Was she taking care of utilities at an apartment address she was not living?
She wasn't taking care of it, no, but she was supposed to.
Did you ask her to cover utilities for the apartment at 480 that she was residing?
Yes,
You testified you asked her to move in or invited her to move in October 2021?
yes,
You also testified that you filed an answer and counterclaim.
yes,
In that answer and counterclaim, you also testified that she would not let you leave with your son?
we're talking about separate incidents.
Correct, but in the answer and counterclaim, you wrote that she wouldn't let you leave with your son?
August 24th, yes.
Was that the 480 address?
No, that was that was our previous address.
And also from that answer and counterclaim, you stated she yanked objects from you?
Yes,
During that incident, did she do any other violence?
she chased me, 9 months pregnant.
Did she physically touch you?
Yes,
How did she physically touch you?
she stopped me from entering the driver's side of the car.
She didn't push you from the driver's seat?
No, she grabbed me and then she grabbed the door.
I'll also talk about the December 20th and 21 answer and counterclaim. You said you had a mattress in the living room?
I'm sorry, can you say that again?
Did Ms. White have a mattress in the living room of the 480 apartment?
I believe she used my mattress.
But there was a mattress in the living room she was sleeping on?
It was actually in the bedroom. I gave her my bedroom while she stayed with me.
So she did have a room at the 480 apartment location.
My room, yes.
She also had clothes there?
Yes.
Clothes enough to go to work with,
She had to buy a uniform.
but she had clothes there enough to go to work with.
Yes.
And it was enough clothes more to prepare for at least more than 1 day's of work, right?
I'm sorry.
She had enough clothes at the apartment for more than 1 day of work. She had more than 1 shirt.
I didn't look in her closet.
Did she have more than 1 pair of shoes?
Yes, they were scattered everywhere.
Did she have shirts scattered everywhere with the shoes?
Yes, that was also a problem that we were having when I would ask her to clean up. It was an argument.
So she had multiple shirts, multiple shoes,
Yes.
multiple clothings to go to work?
I don't know which job you're talking about.
She
Because
also,
for one job, she had to wear a uniform. And for the previous job, she wore a nightgown.
but that previous job, was that a work from home job?
Yes.
So she was working from the 480 residence with that job?
Yes.
Were you aware of that?
Yes.
Now I'm just gonna go back to December 30th of 2021, specifically around 1 a.m. You testified you're in the back room with the boys,
Bedroom. Yes.
but the boys are there.
Yes.
You also testified you didn't hear a knock at the door.
Correct.
There's no doorbell at that apartment, correct?
Correct.
So you wouldn't have heard the doorbell.
She said that she knocked while she was testifying. And so I was saying there was no knock.
Did you ever hear a knock?
No. But I was awake.
But you did testify you heard something at the window.
Rattling, yes.
How loud was that at the window?
It wasn't that it was loud. It just didn't sound like the thunder and lightning that I was hearing. It continued. So that made me feel like something else was happening.
You did hear thundering and lightning, correct?
Yes.
But you didn't hear a knock at the door.
No.
What happened when you you went to the window when you heard the noises?
I had the flashlight on and I was just like flashing to see. And then I peeked in the kitchen and I saw the window up.
You testified you had your iPhone flashlight to do that?
Yes.
You had it in your right hand?
I think it was my left hand.
Were you recording when you had that flashlight on?
No.
At any point during this interaction, were you recording?
No.
I
didn't have time.
You saw Miss White inside of the window, correct?
No.
You saw Miss White?
I saw Miss White.
Where was Miss White?
She was just like I'm on this side of the podium and I come across. That's what she did.
You testified and you gave an example with your body that you were propping the window up.
She was like this.
I apologize, I cut you off. What'd you say?
She was propped up.
Let me just correct that, make sure I got that. She's propping the window up. You're walking over to the window?
No, let me clarify for you. So when I approached the window, she was not propped up. Whenever I got to the window, she immediately became propped up. She took that position. She wasn't already there.
She immediately became propped up.
Yeah.
And she's not at the window?
Are y'all hearing me?
Yeah, where is she?
She's at the window.
Is she through the window?
She was never through the window.
How did she get there to the window?
I was asleep. I don't know. She had to open it from the outside.
But you did testify you walked up and saw her.
I walked up and I saw her approaching, like from one side to the other.
So you're testifying she's just walking past the window?
She was not walking past the window. She was on one side of the window and then she came in the middle of the window.
You didn't see her open the window?
No, I just saw the window open.
You already testified that you already saw the window open. How close did you get to the window before you tried to close it?
How close? So in the kitchen, I walked across and I just saw her. I saw the window, then I saw her over there. And then from that point, I have like a washer and dryer right there. I just sprinted to the window.
You sprinted to the window to close it?
Yes.
Her hands are in the window, correct?
No.
Fingers are in the window?
Nothing.
Arms are in the window?
Nothing.
She's screaming?
Nothing.
Were you aware that she did have bruises?
No, not until she posted a video on Instagram claiming that she had been abused her entire marriage.
So are you aware now that she did have bruises from that incident?
Yes.
And you found out through social media?
Yes. My family sent me the video.
And your family sent you the video?
Yes.
Judge, those are all the questions I have.
May we redirect? Yes, Your Honor. Mr. Williams, you told Ms. White to leave about a week or two before this incident.
Yes.
You gave her the opportunity to get her belongings out of the apartment.
Yes. And I
did
called
not-
her family for assistance.
And she did not get her belongings out.
No,
Would you have stopped her from getting her belongings out if she had told you that's what she wanted to do?
I actually tried to help her.
But would you have stopped her if she was trying to?
No.
In regards to what was asked about the conditions, being an excellent caregiver, paying for utilities, having a job. Those were conditions that you set in order for her to live with you,
Yes.
and she did not help pay for utilities.
No.
And in terms of being a caregiver, was she a terrible caregiver all of the time?
She was not a terrible caregiver all the time.
But were there instances where she did not watch the boys?
Yes.
And then I believe you also said that she was turning back into the Ariana that you used to know.
Yes. She would use the kids to get to me, meaning she wouldn't do certain things that the boys needed to get done just to upset me.
And are you also referring to the self that she was in relation to that letter, that emotionally, physically, and verbally abusive?
Yes.
Were there any specific instances of verbal, emotional, or physical abuse while she was living with you?
There were a few, yes.
Can you describe at least one?
There was one where I had asked her, to watch the boys. I was getting ready for work and I had walked in the living room. By that point, we had switched. I told her get her stuff out of my room, and she took space in the living room. And so I had gotten myself and the boys ready, and I had told her, I said, the least that you could do is help me with the boys if you're not going to do anything else. To which she got up and started recording me, asking me if I was gay, accusing me of sleeping with people while we were together. And I don't know if she didn't know if I knew that she was recording or not, but she literally got out of the bed in the living room and chased me and the boys to the kitchen where I was preparing their bottles for daycare.
No further questions, Your Honor.
You testified that Ms. White asked you or accused you of infidelity.
Yes.
Were there examples of infidelity?
Your Honor, objection, relevance, whether or not there was or was not.
I'll change. You also testified that her elbows are in the windowsill, correct?
Yes.
And that you're pushing down, correct?
Yes.
You weigh about 160?
At the time.
And so about 160 pounds coming down, correct?
Yes, but she was over 200.
About 160 pounds coming down, correct, on the windowsill?
Yes.
And that you are aware that she had bruises from December 30th, 2021?
I was aware after the fact.
And that you pantomime that she's in the window holding it up right where her triceps are hitting the sill?
Yes.
No further questions.
Thank you, sir.
Thank you.
Call your next witness.
State press, Your Honor.
Anything further, Ms. Helen?
No, Judge, just closing.
Okay. To proceed. You ready, Ms. Helen?
Yes, Judge. Judge, we are asking you to grant this immunity motion from prosecution under OCPA 16.324.2, Judge. And I just want to make sure I have all of my case law that I'm about to give here. The standard of review that we're using is a preponderance of the evidence. That's state.
Excuse me. Can you slow down just a little bit and use the mic?
Copy.
Thank you.
State v. Bunn, 701 SE 2D 138 2010, where an immunity motion can effectively dismiss this case prior to any type of criminal proceeding, Judge. And that's what we hope to happen today because of the second part from State v. Yapo. Yapo is spelled Y-A-P-O 296 Georgia Appeals 158, in which they found that the defendant's actions of using reasonable justifiable force to prevent greater bodily harm in that case. Third case, Judge, State v. Green 289 Georgia Appeals 802, where the court found or granted immunity for that defendant because that defendant was able to prove that the force used was able to prevent greater bodily injury, Judge. My next case, State v. Cooper 324 Georgia Appeals 32. Judge, given the details and the evidence in this particular case that she was trying to make a rightful entry into her own home, that she was an invitee, there was no legal civil action filed to evict her. That was effectively her home. She had clothes enough to hold down 2 jobs there. She had all of her personal needs. She also had her 2 children. This is the residence that she's currently living, Judge. And in the process of doing an illegal eviction, Miss White was harmed. Injuries to her forceps from the pressure of the window, whether or not her head was in or out in this struggle that may have lasted on a 10 or 30 seconds, the bruises are there. Mr. Williams is aware of the bruises as he was prior to this court date, Judge. And I do hear the answer and counterclaim and the 2 TPOs, but the moment that we're talking about occurred December 30th, 2021, about 1 a.m. as Miss White is trying to make entry into her home, Mr. Williams is preventing her. She uses force to be released from that window. Mr. Williams doesn't have any bruises other than that bite here from that scuffle in the window. This shows she's being pushed into it. And the bite on the forearm would come from her trying at any way to get at Mr. Williams to release this 160-pound pressure that he was applying at that time, Judge. And that is why we're asking this court to grant this motion of immunity from prosecution. Also, State v. Jennings, that's going to be 337 Georgia Appeals 164 ruled trial court did not bar or did not err in barring prosecution on the immunity grounds because the defendant presented sufficient evidence to carry the defenses. That's our burden today, Judge, to prove the reasonableness of the defendant's belief in the necessity of force and that rose to a level of justification to have this case dismissed prior to a jury trial, Judge. And that's what we hope the court rules today.
Favors? Yes, Your Honor. Your Honor, again, this boils down to that A 16-324 A and A2, which is that did she have the right to use force whenever there is a threat in order to prevent or terminate another person's trespass or criminal interference with the real property of her own habitation or personal property? Did she have the right to enter into this property and then use force to be able to do so? We would ask that the judge rejects the defense's immunity motion because she did not have that right. We can show that by the preponderance of the evidence. First, we had that these are separate homes. The case law I showed you is that whenever there is estranged, even divorced, married, boyfriend, girlfriend, even if someone is formerly living together, if they are currently living together, if they have personal belongings with each other, if the 2 parties, one is owned and they say, I do not want you here anymore. And there's factors that can go into the consideration, such as were there conditions placed on the stay? Did they have their name on the lease? Did they have keys to that area? Did they have belongings at that area? And then, again, sorry, I apologize, name is on whether or not the name is on those lease. All those factors weigh in the victim's favor of that she was not authorized to be in this location. And in terms of the conditions themselves, as the victim testified to, Mr. Williams, he told her that she had help watch the kids and that she had to help pay the bills. He testified that she never helped pay the bills. That was one of the basic conditions for her to stay at that location. He testified that she was supposed to watch the kids, but there were times where he had to have neighbors, coworkers, or friends, or himself call out of work to be able to watch the kids because she had simply disappeared. Those are the two conditions that he imposed in order for her to stay there. She didn't follow those conditions. And even regardless of conditions or not, it goes to just a policy concern of if someone is living with somebody else and continues to harm them and have an emotional, physical, verbal, abusive relationship, and they admit to such a relationship, then one party should be allowed to expel the other person in order to protect themselves. Otherwise, and I ask you to look at the concurrence that I provided, otherwise we're in effect saying that one party, as long as they're married, can continue to harass the other spouse simply because they're married, and that somehow gives them an all-inclusive right to enter into the apartment. The reasons why that this was a separate home go on to the fact that Ms. White is not on the lease. She did not have keys to the apartment. She was invited to stay at that apartment by Mr. Williams. She only brought bare minimum items. The rest of her items were in a storage unit. She testified the fact that include dressers, that include furniture that was in a different area. The victim testified that was basically bare items like clothes or pillows or things like that in order for her to be able to basically stay there. He testified that this was supposed to be a 2-month time max. This was not a permanent stay. He was not inviting her to live with him on a permanent basis. They weren't trying to reconcile the marriage. He was inviting her to stay with him purely out of the goodness of his own heart because she was having trouble with her family. And then she took advantage of that and eventually turned back into her old self and continued to physically, emotionally, and verbally abuse him. And at that point, in addition to breaking the conditions, she also was showing signs of being the person he is. At that point, he decided he was not going to subject himself and his children to this person that he had invited to stay with him. The victim, Mr. Williams, testified that he told her at least a week or two before this incident to leave. That he testified that he had given her the opportunity to collect whatever belongings she wanted. He testified he tried to help her, both himself and to get her family members to help get her stuff out of his apartment. He testified that not only did she refuse to do so, but he would have given her every opportunity if that's what she wanted. And then she admitted on the stand that she knew she wasn't supposed to be there because she had broken in the night before doing the same thing and going through the window. Going on to the bruises and overall version of the events. First, as was brought out on direct of the defendant, the bruises photos were taken 4 days later. They're not taken on the night of the incident. They're not shown to the officers on the night of the incident. While she claims they're from that night, the proof is 4 days passed and the bruises could have come from other places. She says that the victim, Mr. Williams, was aware of these bruises. He can be aware that she claims they're from this incident without actually knowing that that is their actual cause. She didn't show any proof of bruises to her hands, even though she's claimed both her hands and the bottom of her triceps were being stuck in the window with over 160 pounds of pressure being applied. Only bruises to one side of her arm. Finally, Your Honor, her version of events just simply don't make sense. She says at one point, and she testified, that her upper torso was through the window. She showed that her arms were extended. She showed that her head was through the window. Whenever I asked her, when did she bite him? She testified that when she was like this and she bit him while she was through the window. She at no point talked about her arm being pushed out of the window and biting the victim as his arm was out the window. The reason why is because her story, it does not physically make sense. If, as she describes, he's trying to physically push the window from above, at max, this is her body that's through, or if she's somehow claiming like this, it's not possible for her head to reach his arms. It doesn't physically make sense. And the reason why it doesn't make sense is because it's not true. And what the more accurate version is as the victim describes, she was trying to prop it open. He then was attempting to stop someone, as he described. First, he didn't know who it was, then he recognized it as his wife. Stop someone from breaking into his apartment. That's as simple as it is. Someone at midnight is trying to break into his apartment, so he attempts to close the window. And at that point, whenever he is trying to expel that person from his apartment, that's when she bites him. Your Honor, that's the basis of this case, is that She was told she wasn't supposed to be there. She knew she wasn't supposed to be there. She didn't have a right to be there. Just because they're married does not mean it's her property and that it's her residence. Because she didn't have the right to be there, because she then used force to attack the victim when he was trying to expel her from his property, she is not immune from prosecution. She is not justified in using the force that she did. For that reason, the state requests that you deny this motion. Thank you.
Ms. Helen,
Yes, Judge.
I do believe that there are material issues of fact that need to go to a jury. I don't think that the burden has been met today for granting the motion for immunity in the matter. So I will deny it. With that said, for both the prosecution and the defense, you've got everybody here. I think this is a matter that should be resolved if you all can get it resolved. And to the alleged victim and to the defendant, y'all are grown people. You have 2 children that you're responsible for. And you're sitting up in here doing this. Y'all need to think about that. So we'll place this on the next available jury trial calendar. But I would encourage everybody, especially given that everybody's here right now, to see if you all can come to some kind of resolution that everybody can be happy with in this matter. There's a lot that still does not make sense to the court on both sides. But if you all can come to some kind of resolution, if not only for your own sakes, but for the sake of your 2 boys, I think that would be, that would be something that you all should at least consider. All right, so motion denied. There's nothing further. I'm happy to give you all some time to talk today. If you want me to do that, I can just go into recess for a while. Or I can dismiss court. What would you all like to do?
Dismiss, because I have the offer from the state.
I was getting also give it amended, but
Oh,
Right, that's what I'm saying.
Okay. I thought it was just to give the offer again. No, sure then.
I mean, you all heard a lot today, so
Yeah.
I think that if there's some, if I don't mind staying here for a while, if you all want to discuss among yourselves and see if you can work it out.
yes, Your Honor.
Yes, Your Honor.
Try and
You've
do
got
so.
someone who's in from out of state, and you've got everyone here. So if you can, I'm happy to stay.
Yes, Your Honor. If we could
Okay.
just have like about 30 minutes, I need to speak with Ms.
All right,
Williams.
So the court will be, and I apologize to everyone that's waiting, but the court will be in recess for about 20 to 30 minutes.
Yes, Your Honor.
And as far as these exhibits go, I will instruct Ms. Allen, I will instruct Ms. Smith to get you all exhibits so they can be attached to the transcript. So if you can make copies of these for the court and get Ms. Allen the originals.
Okay.
Court will be in recess for about 20 to 30 minutes.
Thank you, Your Honor.
Position.
So Judge, what time should I be back?
If you can be back in about 20 minutes, I'd appreciate it.
Okay, thank you.
Thanks.
You said it for status
No, just gonna, if they can't resolve it, I'm just gonna put it on the,
For the other case,
Oh.
you're gonna decide whether you're gonna deny or.
oh, that I'm taking under advisement.
Right, so do you want to put it on another calendar?
Let's wait till I make my ruling on it, and then once I make my ruling, then we can decide where it should go. Well, because if I